Yes. Appeal, my lord, against the order of learned single judge. Connected matter is listed tomorrow, my lord. May I request for this matter also?
Connected matter is
Connected
listed.
matter, please.
My lords, with your lordships kindly, this is a contempt matter, my lords. I'm appearing for the accused in the matter. Citing an interim order passed in the contempt, the state is not approving recruitment of teachers. It's an aided school. Therefore, my lords, there's some urgency. May I request for it on Wednesday, my lords, 29.
But you file it listed within 4 days, 5 days.
Pardon?
Once you file and remove the office objections, it will be listed.
It's a pending matter, my lords.
Pending matter.
Pending matter. I've already filed an application.
But then for preponement,
My lords, there is no date given in the matter, my lords.
no date is
No
given.
date given.
It is never listed so far.
My lords, it was listed last
How
year.
come that no date is given?
My lords, because I had complied in the matter, there was no date given. My
Now
lords.
you see that in all matters dates are given, even if it doesn't reach the hearing. No matter should go henceforth without a date. All right, let us start.
Very well, I'm deeply grateful.
Yes, yes, madam. Yes,
Lordship, kindly, this is a matter against single judge order to allow, register the site in favor of the respondent. There is, I filed the appeal, the notice has been issued, and now it has to be posted for admission. Adjournment.
it will be posted. No, it will be posted within 5 days.
Fresh matter,
No urgency. Yes, madam.
fresh matter,
Yes,
this is a fresh matter.
yes.
There is an order challenging the order.
It will be posted. What is the subject matter?
This matter, sir, is a solve for the transmission line. There is compensation has been awarded.
It will be posted within week or so. No. No memo will be accepted. Yes. Unless the court grants permission, no memo will be accepted. Yes.
Fresh matter, madam. It is a PIL where 1,300 acres of land has been misappropriated by a company. I've noted before the
So after vacation, everything is new. Let it come in due course. Yes.
madam, anytime this week,
It will be listed. Wait for a week. If it is not listed, after removal of office options, you mention again. Wait, see that it is listed. All matters we are instructing to be listed within a week, if not 5 days. Yes,
Contempt matter.
yes.
These matters are coming before vacation, my lord. My lord says directly to comply within 15 days, otherwise stand dismissed. I have compared the office objection with some urgency, my lord, because 23 matter, my lord, admission is not yet listed.
It will
2023.
No memo is necessary.
Okay, one matter, 24 matter, first matter. My lord, now the BDO is going to allot at least one contempt matter. That is the urgency, my lord.
It
They
will
have, they have allotted to some third party, my lord, in spite of the single judge direction. That is one matter, my lord. My lord, any date, my lord.
It will be listed. Wait for some time.
My lord, one date, my lord. Any date, my lord's convenient.
You wait for 4 days.
My lord, I have compared all the offices.
You wait for 4 days.
4 days. Please.
No.
Public interest
No
litigation.
acceptance of memo unless court permits.
The
Yes.
public interest litigation is filed in the month of February, my lord. In the Panchayat property, my lord, that the building is constructed, which is reserved for the government general hospital. But, I have already complied all the objections, my lord. It may be
It will be
listed.
listed. It will be listed. No giving of memo. Yes, yes, Mr.
It was filed in January.
Hmm.
It's not been listed so far. We have
January?
January it was filed.
What is the matter?
The matter is that we sought directives to put this feature on the case diary by the magistrate. And Senate has dismissed that, saying that there is no rules are there.
Signature regarding?
See, over the case diary, criminal case diary, whenever they bring it a case diary before the court. So there is several fabrication of document used to be done by the investigation officer. So we sought a direction to put a signature on the case diary whenever it's produced before the court. That the same petition was dismissed. They're
So-
stating that there's no rules are there in Karnataka. So we are before this honorable.
For that writ petition you are filing.
We have already filed a petition that was dismissed. The appeal is filed in January also. Very significant matter on the short legal point, legal. All the states have that provision, specific provision to put a signature of the case diary. It's
So
amount
like next Monday, if it is not listed since January, then next Monday.
This is a contempt matter, my accused is not considering the representation made by the complainant. there's an urgency, they are developing the property, my lord. A single judge passed an order to consider the representation. They're
Let-
still,
Let it be listed, it will be listed.
my lord, there's only urgencies, my lord. They're not considering the representation.
Every matter cannot be listed by submission of memo. In due course, we listed. If there is unreasonable delay, we are here to see that it is listed earliest. But no memo in every matter. Yes, Mr. Withdrawal. Tomorrow, 2:30.
Your Lordship, one contempt matter, what happened is, Your Lord, there is a direction to restore the revenue interests, they did not do. I initiated contempt proceeding. Thereafter, they took a undertaking before this, saying that within 15 days, they'll comply the order of this Honorable Court. Then again, they did not do it. That's the reason, Your Lordship, I filed an application to revise the contempt petition. There is an urgency because since from 2012, I'm fighting for the matter. Went up to Supreme Court, thereafter remanded, then the court decided it. And now again, Your Lordship, when there is a when there is a direction to restore the revenue entries, even after undertaking before this Honorable Court.
When you have filed it,
Prior to the vacation, I filed an application, Bella.
it will list, wait for a week. Yes.
Blood, this is PA filed in the month of March. The issue is one of the philanthropists in the year 1935. 5 acres of land given to the veterinary hospital and accessories. Blood, now the government has in the month of February, they have passed the order to hand over this entire 5 acres of land to the minority institution. Now the existing, it's a nerve center of the entire Bangalore city, where several activities are taking place. Now they want to demolish and they want to replace this veterinary hospital and they want to close it. They cannot do it, and it's because 2-3 times when the matter has been raised before the assembly, they have refused. Now they have taken decision in the month of February. I am before the Honorable Court in the month of March. Similarly, when I moved this application or memo, my lord said if everything is complete, matter will be listed in the month of April. Matter is not listed.
It will be, once it is
And
listed,
there is an urgency because the survey conducting and also taking all other activities of construction demolition, it causes a severe damage. It is irreparable damage, my lord. That's why there is an urgency. Repeatedly, in the earlier occasion also I requested, my lord said that office objections and again need to list it.
firstly, I am not recollecting anything what happened before vacation.
My lord,
And when the matter is listed, we'll consider on merits.
my lord, it is now everything is compliant.
Not a case to be listed upon submission of memo, yes.
My lord, it's not because there is an urgency. Otherwise, we would have allowed it to let it come in the usual course. There is some urgency.
No, not in usual course, in due course.
Element of urgency.
Will come
there,
within
that's why
one week or 10 days.
We are requesting, my lord.
So we are answering that, let it be listed, not by memo, yes.
My lord, representative for the appellant, and this is, we are the responsive state of Karnataka, and they have acquired the land and without giving a notice, they have started to, encroach upon the property. So hence this memo for posting, my lord.
Pardon, I am not getting it. Yes, repeat.
Yeah, this is,
Yes,
yeah, representative for the appellant, and the responsive state of Karnataka, they have acquired the land for the KDB, and without giving any notice, they started to encroach the property of the
they have
appellant,
started what?
encroaching the properties. my lord.
Encroaching the
Yep.
property. Listed within a 1 week. Wait, yes.
My lord, in 2017, I have applied for quarrying license, my lord. In 2019, there was a direction of this Honorable High Court stating to consider my application. However, till date, my application has not reached an ultimatum, my lord. I have filed this matter in January, my lord.
January,
Yes, my lord.
next Tuesday.
Obliged.
With your lordship's leave, may I mention list 1, item 29?
Wait, yes,
With your
Can I-
lordship.
yes.
The counsel is in, the counsel advocate on record is in personal difficulty.
Tell him to wait.
Please mention after the memos are mentioned, sir.
Sorry.
Yes, come, take the mic. Be audible.
My
Take,
lord,
take the mic. Yes.
this is the matter For PIL, my lord, this is a fresh matter against BBMP, my lord. This has to be posted next year. After 4 days, my lord, because it's some urgency in this matter.
What is the subject matter? What is the subject matter of PIL?
Construct the wall, my lord, because of rainwater, it gets stuck into the.
It will list it after 2 weeks.
Serial number 40. So we are appearing for accused number 6, CA6. So the matter is posted for further orders. We are already made payments and the part, it is a matter is parted before the court all 2 minutes. Hence the matter may be heard on the same day.
No, it must be given some date. Which matter?
My lord?
Which is new matter?
No, my lord.
Serial
for
number
memo, it
40
serial
is
number
mentioning.
40.
Here,
Serial number 40. The matter is posted for further orders where we are already made a parted.
This-
With regards to payment and the necessary payments for also made, further payment has to be made. And the matter is parted before court all 2. Hence the
We'll
matter may
adjourn
be
this.
held,
We'll adjourn this.
matter may be
Contempt.
same bench.
This is contempt.
it is
Contempt.
tagged with writ appeal also. The submission is that, my lord, writ appeal was heard. And
No,
part-
contempt petition is aborted.
Let it be called out. Let us see. We'll see when it's.
Wait, please, my lords. My lords, we have filed a writ petition seeking a simple mandamus. The issue is that, the proceedings have been conducted by the Pollution Control Board, where a direction has been issued to close my 2 units on the basis of certain non-compliances. But there has been a report of the Assistant Environmental Officer which has not been considered. So our only prayer in the writ petition is that they may consider it and pass orders.
When it is posted, we'll consider it.
My lords, the urgency is because the orders should not be passed for closure of the units, because there is already a direction. Since they have not considered the report of the Assistant Environmental Officer, which says that everything has been complied with.
But there is no reason to believe that it will not be listed within 4 or 5 days.
My lords, at least one direction for listing, my lords, because the unit should not be closed.
There is a general direction for listing earlier. Yes, anything?
Grateful.
My lord, serial number 32, my lord, price weeks
32.
time. 32. my lord.
Yes.
Yes, weeks time, my lord, because advocate. Yes,
Only. When shall we keep? 19th June.
obliged.
My lord, serial number 17 and serial number 54, my lord. I'm for the appellant. There is another matter which we have filed on the same orders, my lord. So that matter has not been posted, my lord. So altogether, it may be heard, my lord. Hence, short accommodation may be given.
Let it be considered, hold out, yes.
The other
At-
matter is,
At that time, you may request.
Serial number 20, my lord.
25,
20, my lord.
20.
I am for the appellate. May I seek short accommodation of 2 days, my lord? I am for the appellate.
No, let it be called out.
Item 29, list 1, may I mention your
29, please check up it is belong to this roster. 29. It is. Yes, Mr. Yes.
Yes, Your Lordship, the advocate on record is in personal difficulty. I'm just seeking a short accommodation by 2 days. If your lordships can adjourn it by another 2-3 days, any date convenient.
Next Tuesday.
Lord, I appear for 4th respondent in connected matters. 2 weeks it can go.
2 weeks, 2 weeks.
Because we have to file objections also, my lord. Let it be 3 weeks, my lord, so that we can file.
2 weeks. Very good.
Your lordship, there is some issue of interim order because this matter had to be listed for interim consideration. They may proceed with the lease execution. That's why.
It itself has become infructuous.
Since we have executed,
see
my
our-
lord, MDPA.
After 3 weeks,
2
your
weeks.
lordship.
2 weeks.
Very good.
Obliged.
June.
The contempt matters, seal number 1.
I'm for the petitioner. Lords, on the last date of hearing, Lords just wanted to know if there's any specific direction in this matter. The learned single judge, my lord, has given a specific direction, directing the
It is
respondent.
pending before Supreme Court.
Yes,
Please.
ma'am.
Now
On
there
the
is no
last
stay in
occasion
this-
also, I made a submission. The matter is likely to be posted before the bench, not
When?
in Supreme Court.
When?
No date is given. my lord.
Date is not given, Lord. We are awaiting. We are
Been
moving
two
the
and a half
matter
years, my
before
lord.
the apex
Well-
court. At the same time, Lord, a suggestion was made in the last occasion to the effect that, Lord, let them register their vehicle in the normal course of registration. In the case, if we fail in the Supreme Court, Lord, whatever the excess tax amount which they have paid will be adjusted under 7.3, Rule 7.3 of the.
I would make the same submission, my lord. The BH series registration is valid only for 2 years, either ways. We don't know when the matter will be listed before the Supreme Court. Now, my lord, I am willing to pay the entire lifetime tax. Let them give me BH series subject to the outcome of the SLP. I'm willing, their
No
only ground
prejudice
is
will
that,
be caused, my lord,
my lord,
even
kindly
if they-
allow me to submit. Their only ground is that, my lord, that they are suffering loss of motor vehicles tax. I'm willing to pay the entire lifetime tax.
Fine.
Willing to pay the entire lifetime tax
It will be same amount.
with the same amount.
It will be same amount, Mr.
Yes.
Government. Advisor.
Subject to the outcome of SLP, let them give me BH series. My lord, this will affect lakhs of people.
Probably the council is saying the same thing which you are saying.
Yes, yes.
Ah.
Let him pay the lifetime tax and get the
BH
vehicle
series.
registered.
Let them give me BH series. Because I can't travel without that, my lord. That is the difficulty.
Yes, series can't be given for this reason,
That is
because
not
that
fair, my
is,
lord.
the very fact is put in challenge before the apex
There is
court.
no, my lord, I personally appeared before the Supreme Court,
So, Mr.
in spite of strenuous arguments by the learned senior counsel there.
They stating saying that if you register in normal,
Yes,
under the normal rules and pay the tax,
yes,
if ultimately you succeed, the excess will be refunded.
yes.
Like, I have to pay unnecessarily lakhs of rupees, my lord, for nothing, my lord. It's not just affecting me. It's affecting several others here in the state, private sector employees. How would they cough up that kind of money, my lord, if they are actually eligible for BH series? All I'm saying is this, I am willing to pay the entire amount. There is no difficulty in giving, because kindly see this, the Supreme Court actively refused to give an interim order.
Give the details of the numbers, etc., which is pending, SLP is pending.
Two SLPs are pending, my lord.
Lord, I have, the last occasion also I have paid you.
Yes, it is given. The diary number is there.
The SLP 675 and 676.
I am appearing 675 there.
SLP 675
And
and
676.
676 of 2024.
Please.
Yes.
Now, what is the direction of learn a single judge? Actual direction.
My lord, I have the.
To register,
I have
to
the final
register
orders,
the
my lord.
vehicle of the
Specific
petitioner.
direction is there to direct, to register.
It is learn a single judge only set aside the notification.
Not just notification, with a specific direction. And your lordships here held that there's no reason to interfere.
And what happened to this 11, another notification, subsequent notification? Some subsequent notifications were issued by the state government.
Yes.
Which is, that is not set aside, Mr.
No, my lord, there is no other notification other than this.
There is no other notification.
No other notification. Other than this was the only one which was under challenge, which was quashed, and thereafter your lordships have confirmed the learned single judge's order. Lordship sees the third para of the order. The Commissioner Transport and Road Safety, Shantinagar so-and-so, respondent number 2, is directed to register the motor vehicle of the petitioner in WP number 683 of 2002. Then the fourth one is the state government is directed to implement the Central Motor Vehicles 20th Amendment Rules 2021.
You take instructions whether you are willing to accept the suggestion of the government, they will pass some order. Day after tomorrow.
Day after, my lord.
Your lordship may kindly have it after vacation, Lord. It is likely to be posted immediately after vacation before the Supreme Court.
No, my lord, there is no date given, my lord. This is.
We have to pass some order. They are in line
Contempt
waiting.
I understand.
So we are asking them to consider your suggestion only. What they are suggesting about payment of tax, which is payable in normal, under the normal rules. If you succeed, the excess will be refunded.
Yes.
Right, in that case,
if you want your vehicles to be registered and ply in different states, but then you don't take coercive action against the vehicles which are otherwise registered under the regular rules, normal rules, if they pay the full tax. Day after tomorrow.
my lord, in that case, I'll go ahead with the Karnataka registration subject to the outcome of the SLP. Because my client is in dire straits. He's unable to use the vehicle. There's no point because it's been 4 months, my lord.
So ready.
I'll register on the case series subject to the outcome of the SLP.
Put a line on the affidavit.
Please.
In that regard, because this is contempt jurisdiction.
Please.
Will you be passing order only upon your
lordship may have it on
kind of concession, not concession, but you put your affidavit that you are ready to pay something, so that we'll mount the order.
Please, my lord, but there's one other thing I have to bring to your lordship's attention, that if lordship sees para 21, my lord, there is about 2,22,000 rupees of penalty that is imposed for not registering after my temporary registration expired. While I was pursuing this matter before this court, that has to be commuted, my lord.
That we'll see. First, you put on affidavit that you're ready to.
Lordship may have it on Thursday, my lord.
Whenever.
Thursday.
Thursday at 2:30.
Publish.
2:30.
To be listed on Thursday, which date? 30th May at 2:30 in order to enable Governor Advocate Mr. So and so for the contempt petitioner to file an affidavit.
Obliged.
Obliged.
This is number 2, the Sagar V. Shah.
Complainant.
Please, your lordship.
Please, your lordship. Now, page 70. Page 70 is the direction issued by this honorable court. With regard to the, my lord, the land belonging to the petitioner has been utilized for formation of link road without payment of compensation.
Notice written.
Highly obliged.
There's a delay of 372 days.
In which? Delay?
Delay number 2.
In contempt.
Delay is there.
How do you get out of delay?
Lord, the order was passed, page 79, my lord. Within 4 months, my lord, they were directed.
But section 10 provides to the
Lord, it's a
period of 1 year.
Lord, it's a
continuing cause of action.
Please.
That is time.
Because they are still utilizing, my lord.
That is talk.
Page 70 is the direction. If
Page-
they determine, my lord,
Page 70.
direction issued by this honorable.
In fact, municipal council has passed a resolution for payment of compensation. Only thing is they have to determine.
While submitting that, the directions in the order
Please, my lord.
dated September 2021 of a single judge are not complied with, then the compensation as directed is not paid. From learned senior advocate, so and so, the petitioner submits that the cause of action to prosecute the respondent under contempt jurisdiction is a continuous cause of action. From on the other hand, learned government advocate, Miss, what's the good
AGM,
name?
Pramodini Kishan.
Pramodini Krishna.
Kishan.
Krishna submits that the time of 1 year has already elapsed from the date of passing of the direction filed on a single judge, tendering the contempt petition beyond limitation, full stop. Keeping all the aspects open, to be considered at a later stage, notice returnable.
Respondent number 3 is private respondent.
Returnable on 11th June. Learned government bidder, additional government bidder, waives service of accepts notice on behalf of
1 and 2.
1 and 2
1 and 2.
and 4 and 5.
1, 2, 4 and 5. The rest of the respondents shall be served.
Please. Oblige.
Number 3 to Vinayak P.
I appear for the complainants. My lord, the complainants are assistant executive engineers, my lord, working in BWSSP.
Seniority list.
Seniority list, my lord, was challenged and set aside. And my lord, a consequential order was passed, my lord, setting aside the DPC proceedings. My lord, now, my lord, after filing of the contempt petition, I am learned that, my lord, seniority list has been prepared. But, my lord, the probation has been declared thereafter, my lord, after communication of the
notice returnable on.
My lord, I appear for accused 1 and 2 in this matter, my lord.
13th June.
I have appeared for accused 1 and 2. I have appeared, my lord. If I shall file my reply in this matter.
Learned advocate so and so appears for respondent number 2 and 3.
1 and 2.
1 and 2. 1 and 2. And accepts notice. He further seeks time to file reply.
Much of
reply may be filed before the next date.
Much of
great.
This is number 4. Lakshmama SB.
Complainants and others, nearly 125 petitioners have filed the writ petition, my lord. The said writ petition is still pending for consideration, my lord. Will Lordship kindly come to page number?
Which order is under contempt?
This is
Interim
against
order.
interim order.
Against interim order, my lord.
Interim order.
Interim order.
Then why you are pressing for contempt?
Because, my lord, will Lordship kindly come to page number 10, the operative portion of the order of the learned single judge, my lord. I am reading about the last 3 lines, my lord. In the light of the above, the respondents are directed not to relieve the petitioners from their services till the next date of hearing, my lord. This was the order passed by the interim order.
It is a tentative order till the next date of hearing.
No, matter is not at all listed before the learned single judge.
It will be listed. It will be listed.
Already 5 to 6 petitioners have been relieved. So in spite of the order of the interim order, my lord, so the respondent accused 1 and 2 have been relieved from the services. This is a clear violation of the interim order passed by the learned single judge.
As far as interim orders are concerned, and this court is concerned, it is almost a matter of rule that the interim orders are not subjected to contempt jurisdiction. And we are not exercising contempt jurisdiction. If you invite an order, we'll dismiss it. If you want to go to learn a single judge, we'll permit you. Choice is yours.
So let the matter be go on with the learned single judge, my lord,
Learned
because I have been relieved because I am
Learned-
not in service, my lord.
Learned counsel, Ms. Lakshmama SB, for the contempt petitioner, from having realized and accepting that the order brought under the contempt jurisdiction is an interim order, and that the proceedings of the writ petition are at large before learn a single judge, comma, opts to approach learn a single judge in relation to the grievance raised in this contempt petition, full stop. The permission is granted, this contempt, full stop, this contempt application is not entertained, full stop. At this stage, learned counsel for the petitioner stated that the writ petition is not being listed before learn a single judge, full stop. It is provided in that regard that if no date is given in the writ petition to be listed before learn a single judge, the same shall be listed on 5th June.
Please.
Contempt petition is disposed of accordingly.
Number 5, Mr. Manjunath H.
Appearing for the appellant by me, my lord. My lord, this is the final order passed by this honorable court in MFA 1934 of 2023, ink page number 12, my lord. In the final order, this honorable court restrained the accused number 1 and 2 from directing the parties to maintain status quo in all respects as on today in relation to the suit scheduled property till the disposal of the suit by the trial court. In this regard, my lord, on the date of disposal, the accused counsel has filed the annexure R7 and 8 showing the status of the party.
This order was passed on when? 20th?
20th April 2023.
The suit
My
was
lord.
directed to be disposed of within 6 months.
6 months.
Suit is still pending.
Still pending because of the transfer of the judges and vacant court. And the status of the property.
Notice returnable on 19th.
Obliged.
Number 6, Mr. Jnanesh Kumar K.
For the complaint, my lord. The complaint has been working as a peon, my lords, in Vidyardhaka Law College, my lords. Any page number, my lordship, 26, my lords. So appeal prepared by the government has been dismissed, my lords. And I directing the accused to consider comply the order passed by the learned single judge, my lordship, within 3 months, my lordship. Till today, they are not considered, they have not passed any order, my lordship.
So what was the direction of learn a single judge?
My lordship.
By the division bench? Where is the
My
order?
lordship, page number 23, my lordship.
23 is.
Oh, my lordship, sorry. 1 minute.
This is revision bench order under contempt. What is the?
No, my lordship is working under the college granting aid, my lordship. That benefit has not given to the complaint, my lordship.
What is the actual direction?
My lordship.
We want to see. Which is confirmed by the division bench.
Yes, my lordship.
Very good. Pass it over. If you have got the copy of learn a single judge order.
Yes, my lordship. Page number 10, my lordship.
Page number 10.
10, my lord. Concern raised, state respond is hereby directed to pass a speaking order in approving the petition for appointment within a period of 8 weeks from the date of the receipt of this order, and
Notice.
consequently,
Notice returnable on
please, my lord.
14th June.
Public, my lordship.
Number 7, KSV Prakash.
The order of the single judge is at my lord, page number 26, my lord. Relevant to operative portion of the order is at page number 37. Lord, single judge has directed the authorities to initiate the acquisition proceedings and to pay the compensation to the petitioners, my lord. Till today, they have not complied the order.
Lords, we,
Appeal is pending. Appeal is pending against this order.
no, my lords, we are complying the orders. It has been initiated, my lords.
Complete the order.
Initiated the compliance, my lords. The draft notification for acquisition has been proposed, sent to the deputy commissioner. my lords.
Yes, what is happening? Appeal is filed or you are complying? with?
We are complying, my lords. We will file the affidavit within a short while, my lords. Your lordship may grant 3 weeks' time.
But the process of acquiring the land is initiated.
Please, my lords. It has been initiated.
Anything is there to show?
Lordship may
Then we
kindly
can
pass
discuss.
over the matter. I will produce the
We'll pass over
records.
2/3.
Please.
If it is something initiated, then we'll dispose of the contempt.
Number 8, to Srinivas K.
the complainants. Complainants are the retired employees of the accused company, but who have not the terminal.
Arrears of salary to be paid.
Please,
Notice returnable on 19th June.
Serial number 9,
but,
to Srinivas K.
this case, my lord, the order passed by the sum of by the learned single judge, my lord, what annexure E, my lord, has not been complied with by the accused, my lord, in spite of representations made by
The
the.
same.
This is, my lord, regarding payment of the sanction of increment, which, my lord, the sound book.
This increment,
Please,
July 1st,
True.
retired on 30th June.
true. The even Supreme Court also, my lord, affirmed the
Yes,
order passed.
Yes, we are aware. So they are not paying.
They were not yet paid, my lord.
Difference, you are seeking difference of,
Please.
who will appear?
Not, before, BL Sanjeev also appears for KPTCL. And Chandrachud, my lord, had appeared on the earlier case.
So notice,
Please, I will take out.
18th June.
Next matter is also.
10.
similar. This is also similar, my lord, similar to.
Then also similar.
Please.
Same.
Serial number 11, Mr. Nitin Prasad.
The complainant's petition was allowed, my lord, by the learned single judge. My lord, the order, the operative portion is at page 24.
Read the directions.
Yes.
Read it.
Not page 24, my lord,
Yes.
just above para 7.
Yes.
But it is made clear that the petitioner is entitled to have a dedicated line subject to working out the modalities. My lord, this is for electric vehicle charging in an apartment complex. Not then para 7, the writ petition is accordingly disposed of with a specific direction to the third respondent association to consult experts in the matter of giving permission to individual apartment owners like the petitioner to have their own dedicated charging station in the car parking area, and thereafter proceed if the experts are of the opinion that permission can be granted while following the requirement of law and guidelines issued by BESCOM and regulatory authority. Needless to observe that, that I may skip, not then the last 5 lines.
Why you will keep this? It is your participation also.
Yes, that's also true. I have produced emails also to that.
So have you approached the authorities to start the process?
I have also done it. In fact, on my persuasion, BESCOM has replied to the association.
So you appointed your own expert?
No, I couldn't appoint, I could only suggest and participate.
Yes.
Then also they say, you cannot be there, you don't have a say and all that they've said. But within 4 weeks, it was to be done. After persuasion, they write to BESCOM. BESCOM, there is some gray area, so they did not reply. Then they reply,
Who will appear? Mr. Mahendra.
This is, a private respondent.
Private respondent.
The president of the association who was directed to get this done.
Not the Bengaluru electric supply. You are.
I am one of the owners, apartment
owner.
Yes.
But this dedicated line is to be provided by.
Me, installed by me.
Not to be provided by who?
It will be drawn from my BESCOM meter and installed in my parking slot.
To be provided by this company, electricity company.
No, they have already said before the learned single judge that they have no role to play in the matter. In fact, I had produced their questionnaire also, which they had published. That is also referred to. I am to draw it, by following their guidelines.
So there is no role for number 2, Bengaluru electricity company?
No,
No role.
Not after the learned single judges.
Notice. Returnable on 18th June.
So PL matters, serial number 12, Mr. Ravi Shankar SS.
My lord, I appear for the petitioner. This is a public interest litigation that is filed against the Archaeological Survey of India, the respondent number 1, for dereliction of their duties of conducting their mandated duty of conducting a survey.
Archaeological survey. Archaeological survey. Now, this masjid is right now administered by the archaeological department.
Yes.
So then how
Yes.
can you change it, the everything?
And
To the writ petition.
my lord, see, we got independence in
Is
1946.
there any power to revisit the letters?
One of the duty of the archaeological main survey is to conduct surveys for me. I will read out the consent. This one in Ancient Monuments and Archaeological Sites and Remains Act 1958, Section 21, Swami. It says the excavation in protected areas, an archaeological officer or an officer authorized by him in this behalf or any person holding license granted in this behalf under this act may, after giving notice in writing to the collector and the owner, enter upon and make excavations in the protected area. The name itself.
Where you are reading?
I'm in section 21.
Section 21.
Section 21.
Ultimately, you want the
So the
the status of the protected monument.
and they are supposed.
So once it is a protected monument,
Ah.
what is the procedure, if at all you are right, whereby the entire status can be changed? What is that procedure? Is it
No,
permissible?
the procedure is, see, the duty of the Archaeological Survey of India is to conduct timely surveys, to do excavations and to bring out the truth to the masses. They are supposed to make report.
After excavation, what is the?
They are to publish the reports.
Let us see, where is that? Publishing a report is kahan hai wo? Where is that? Where is the provision about publishing of report? Excavation, yes. But unless you show, we are not clear about for what purpose they should excavate.
If you can kindly come to page number 72.
72 we have seen.
72 of my petition.
Yes, yes.
In that, the Archaeological Survey of Mysore,
We are
in
aware
that
about
there is, they have published this report
So we are
where it
ask-
says,
We are asking that if you are right in on this count, page 72, then what is the mechanism under the law, namely this act, to have your status altered as per your perception?
the commissioner of the concerned district is supposed to instruct the Archaeological Survey of India on following the protocol from the directions from the state and the center, and instruct the Archaeological Survey of India to conduct a survey and to bring out the report. So I have approached the commissioner.
So go before that authority.
I have gone before the commissioner. I have gone before the state. Both of them have directed the Archaeological Survey of India to conduct.
Where is that?
That I am coming to. That is
You are for?
page.
State. 79.
It is page number 92.
Page 92.
Annexure C2. It is the report of the commissioner. The translation is in page number 93. It says for me, reference to the above subject.
No, 96.
Both.
Which page? 90?
93, Swami, 93. It is a translation of page number 92.
Yes. Reference to above subject.
Yes.
It says referred legal notice is annexed along with for your necessary action. And again, the office of the chief minister, I have gone before them also. And they also, in page number 94, which translation is available in 95, says reference to the above subject has submitted pleading to Honorable Chief Minister on Jamia Masjid at Srirangapatna Taluk. In this reference of said plea to Honorable Chief Minister, necessary action in accordance to the procedure is solicited. It says so.
You are for a department?
Lordships, I appear for Archaeologist of India minutes. I seek a week's time.
You are appearing for?
Archaeologist ASI.
ASI.
ASI. I seek a week's accommodation, take instructions, my lords. I received the notice only in the month of March 2024. I could not get even the petition copy also. I seek 1 week's time. I say take instructions, make submissions, my lords.
Now this commissioner, etc., will direct the archaeological authority under which provision?
Under
To undertake survey, etc.
Under section 21 of archaeology.
21 is excavations in the protected area.
Yes.
An archaeological officer or officer authorized by him in this behalf.
Yes.
Or any person holding the license granted in this behalf under this act may, after giving notice in writing to the collector and the owner, enter upon and make excavation.
Yes.
But where is the provision whereby the commissioner can direct to undertake the survey afresh?
No, under the duty of Archaeological Survey of India.
Page 93 and page 96 which you showed. If it is to be implemented, under what provision?
It says, kindly. See this.
What is this?
It is the duty list of the officers. It says.
We don't want duty list. We want the statutory provision.
In that it comes under this system. I'll just read out to function as the head of the Archaeological Survey of India, which is primarily engaged on basic research in various disciplines of archaeology, including archaeological excavations and explorations, protection of monuments, sites of national importance, their proper maintenance and upkeep of carrying of archaeological
They are maintaining
conservation.
this religious place. They are maintaining this religious place.
No, they're not maintaining it. 1935 onwards, 1935 was the last excavation that was done. Now it is not even being maintained. In fact, it is in a depleted condition. It may fall anytime.
It is declared as protected monument.
It is a protected
So where
monument.
is that order? What is declared as such the protected monument? The site, the place, the land, the religious place, or the place you want to be declared?
In ancient monuments and archaeological sites remains rules at page number in Karnataka 30, Mandya Srirangapatna. So it's a category B monument. And the Council for Archaeological Survey is here. So he can also assist the court.
You are not supposed to make the communal pleadings. What are you?
No, it is not
Look
communal.
at
I
your-
never asked for anything.
Look
I
at your,
won't-
on this ground only will dismiss with cost. Look
No,
at
no,
your,
my lord.
look at your list of events, Mr. Counsel, page 11. We will not tolerate such type of pleadings before court of law, that too high court. Even a color of communal approach
No,
will
it is
not
not at
permit.
all. I
you.
never
Will not
asked
be-
for anything.
To read it aloud. In the presence of all, what you are pleading. Disputed structure, so and so, read it loudly.
Disputed structure Jamia Masjid constructed at Srirangapatna on the major remains of Moodla Bagilu Anjaneya temple illegally against the aspirations of crores of people in general and specifically against the intents of lakhs of people of Mysore by Tipu Sultan during 1786 and 1787, which till
What
date
is this?
stands as a testimony.
Till date stands as testimony of religious hatred and intolerance.
My
How
my
can
lord,
you say
that is reflection in the archaeological survey that was conducted in 1935.
Let us see if these words are there. The
The
words you
exact,
used.
exact words are not there, but it is said, it is done. It is constructed on the remains of Anjaneya
That's
temple.
that is altogether different. And saying that till date stands as a testimony of religious hatred and intolerance. How can you say that in a pleading before court of law?
If court can allow, I can read out the survey of 1935.
If you are persisting, read out. Please read it. And if you are, if
No,
we
no,
are, if we are wrong, then we'll pardon you. If you are wrong, you will be punished.
My lord, I will, let me be pardoned. I will take back those words.
Let us see.
And I will, if you can, if the court can allow me, I will read out the contents of.
Please read it. Where you are reading.
In page number 70. In page number 70. It says, point number 21.
Are these group of words so important for you in this writ petition? Page 11, words which we drew your attention are so important for you in this writ petition or public interest petition?
No, no, my only intention was to conduct.
To answer what we are asking.
Those specific words I will take back.
In what manner will take back?
Unconditionally, I will take back.
In what manner?
As expressed by this honorable court that it.
Delete this from the pleadings. Then
I will certainly.
Then we'll consider tomorrow.
Much.
Tomorrow.
Much.
You delete by.
I will.
Some writing.
I will. Much obliged.
Yes. You come at 11. Tomorrow at 11. You get it. Where is the council? Yes, at 2:30, tomorrow 2:30.
File I need to delete, take that.
You give, leave to MN. Write down, leave to MN. By way of deletion. Leave to MN by way of deletion.
So green bench matters?
If Mr. Counsel, if those words are there in the body of the petition, then also you delete. We see the point, but you delete this language. That is, yes.
Number 13.
Here for the petition.
Yes.
Let the land bearing survey number 185 is the subject matter. It was granted on 6th of May 1974.
This is deemed forest.
Covered by the judgment.
But then how do we know that it is part of that Supreme Court order? Within the compass of that Supreme Court order? No, this.
Because there is a specific order passed by the forest officer.
Like this judgment has no application, like due respects, my lord.
Why?
There is another division bench of this honorable court which applies. Like this land, my lord, kindly see the facts of the case, my lord. This was granted, my lord, to Mr. It is admitted fact, my lord, on 6th of May 1974, my lord.
6th.
1974, my lord.
6th May
1974.
1970.
Please. Annexure B is the grant certificate, my lord. It was granted in favor of Mr. Dase Gowda.
Annexure.
Annexure B translated copy, my lord, page 38, my lord.
Page 38.
Yes. 40 will be relevant, my lord. from the date of taking possession, 15 years shall not be alienated, my lord, then it is, the grant is, possession is given on 6th of May, 1974, my lord. Now, thereafter, my lord, his wife, Dasegada, he succeeded. And then, my lord, an application is made seeking license under the Karnataka Regulation of Stone Crushers Act, Annexure M, page 107, my lord. Now, this application was sent to the range forest officer. Range forest officer has submitted a report stating that, my lord, it is a granted land. Now, the senior geologist replies stating that way back in the year 1982, a portion of the land was transferred to the forest department for plantation and therefore is a deemed forest. Till the survey is conducted, it cannot be granted. But this very same issue, my lord, was dealt with, my lord, that the notification issued by the senior geologist, my lord, is without reference to the subsequent notification issued by the government. My lord, the senior geologist relying on notification annexure E, page 47, my lord. Page 47 is at annexure E. But this notification is not in existence because subsequently, my lord, the government constituted a committee headed by the chief secretary. My lord, the government decided to withdraw all the C and D lands were granted in the year 1983 to the revenue department, and a notification annexure came to be issued, my lord, annexure F. It is at page 52, my lord. Your lordship, page 52. my lord. Annexure. yeah. Sorry, I think there is. That's 58.
Now, where the deputy conservator of forest has said about this falling within the.
Well, this area is not declared as forest at all, my lord. The report of the range forest officer may kindly be seen, my lord. The notification which there.
Where is the response of deputy conservator of forest?
Well, the deputy conservator of forest has not yet submitted a report, but the range forest officer has submitted a report.
Lord, they say it is a deemed forest, therefore it can't be granted.
We understand also there is Supreme Court judgment. But then where the authority said that this is deemed.
Authority, the range forest officer, not.
Page 129.
Yes, page 129.
He doesn't say it's a deemed forest, my lord, it says granted land. Translated copy, my lord, I relevant to have. It starts at 126. And he categorically says, my lord, it's a patta land.
So what is that area deemed forest? 10 kilometers? Periphery of 10 kilometers?
This particular survey number measuring 400 acres land.
This is covered by your lordship judgment, my lord, at annexure H.
Annexure
page 58, my lord.
Annexure U, in annexure U, it is clearly stated.
Page 129, your lordship. Please,
29, we are on 129. Second
Yes.
paragraph.
Yes.
The GPS reading of the proposed. Mr. Mahindra, see that paragraph. It might help you. Page 129. The GPS reading of the proposed land is so and so and so and so. It says that the proposed area is 13.40 kilometers away from the Ranganatittu bird sanctuary, 3.56 kilometers away from the Gender Hollai bird sanctuary, Holly bird sanctuary, and 2.4 kilometers away from the eco-sensitive zone, and 4.11 kilometers away from Katyali reserved forest. But then we want to see that this area falls within the Land indicated by the Supreme Court to be deemed forest.
The last may kindly peruse page number 152.
That is a reply to my legal notice. My lord. Senior geologist is not the competent authority to say, my lord, is a forest or a deemed forest. My lord. It is a licensing authority headed by the deputy commissioner. It can take a decision.
On Lord, page number 153, that is the last but one page.
156.
153, there is some mistake in the pagination. This is the letter dated 18 or 19/12/2023. Annexure U.
Same land, 185.
Yes. May draw your lordship's attention to the last para of the second page. In the meeting of the District Regulation Stone Crushers and Licensing Authority held on 2/6/2022, the Forest Department submitted the report stating that the original survey number of land bearing survey number 185/P1 is 185 in 1982. As per the order of the Deputy Commissioner, the land has full extent, the 400 acres of deemed forest area that can be identified by conducting the survey along with the Revenue Department. And joint spot inspection is in process. Till receiving the report, decided to hold the application temporarily by the way of the order of the High Court.
There is no report.
There is no report as such. Lord. My instructions are that Lord, this particular land, 400 acres.
Please be on a surer footing.
Please.
What happened after page 163? Find out.
Let subsequently, my lord, after 82, the government withdrew all these lands from the forest department. And the division bench of this honorable court, my lord, I don't know, page, my lord, it has held, my lord. Once is withdrawn, forest department cannot claim administrative control of this at all, my lord. That order of this, your lordships, has become final, my lord.
That is with regard to C&D lands. That is nothing to do with this. In the year 2015, the committee appointed by the Supreme Court have identified these lands as forest lands.
My lord, the Supreme Court, my lord, in Godavaram case, my lord, held, my lord, the lands which are identified in the revenue records must be deemed to be a forest land as on 12/12/1996, my lord. Now the revenue records from the beginning till now, it shows that it's a Gomar land. In so far as this land is concerned, it shows, my lord, private patta land granted way back in the year 1974, much prior to that 1990 notification issued by the Special Deputy Commissioner transferring these land. Obviously, that land which has been granted could not have been included in that, my lord. Then subsequently, my lord, if your lordship could permit me, kindly see the subsequent notifications, my lord, at page of Annexure Z, my lord. Annexure Z, the typed copy, my lord, it is at the next page, 56, my lord.
The last may kindly have it.
Petitioner is desirous to establish a stone crusher unit. Full stop in this writ petition. 3 interwoven prayers are made. Full stop. First is to direct the respondent authorities to consider the application of petitioner for grant of Form C, treating the property on which the petitioner wants to establish the unit, to be a patta land. Full stop. The second part of the prayer is to grant such certificate for stone crusher unit in light of the application of petitioner dated 18/9/2018 made for the purpose. The third part of the prayer is to direct the respondent authorities not to treat the land as forest land or as a deemed forest. Full stop. the authorities have taken a stand that the survey number 185/1 Paiki 185 P1.
180
P1,
185 P1 is granted to the petition. 185 is the.
185.
Yes.
Which is now being claimed by the petitioner is 85 at Angarahalli village, which now is claimed by the petitioner, is a deemed forest. And therefore, the stone crusher activity could not be permitted in the area. Post of learned government leader, Mr. Mahindra, invites attention of the court to the communication dated 18/19/12/2023 from the Department of Mines and Geology, which is indicative of the stand of the authorities that the report was submitted by the, inter alia, that the report was submitted by the Forest Department, stating that the original survey number
Let it
Measuring
says out
400
of
acres.
600 mallet, 400 is deemed forest.
400
It has
acres
to be
was
surveyed is what it says.
deemed forest area. And that the report was to be submitted in this regard. Post of notice to the respondents, directing the respondents to file necessary affidavit, place it on record. They stand about the land being treated as deemed forest and subsequent developments in terms of any report, etc., received from the competent authority. Notice shall be returnable on 19th of June, full stop.
Please.
Looking to the compass of the controversy noticed in course of the hearing today, the writ appeal may be lifted at 2. On that they will dispose it.
Please.
It's number 14. Mr. Ganpati Bhatt.
This case, my lord, I am appearing for petitioner. Last date of hearing, my lord, in other case that I have submitted, that revision authority, my lord, is not taking decision. That is, this is the example, kindly see in page number 67, annexure H, my lord, 2007, my lord, and 8 revision petition disposed of in the year of 2024.
So at the time of coming into force of the amended rules,
before that,
your application was not pending.
Please, my lord.
At the time of coming into force of the
2016 Act amendment. My lord, what happened, my lord? 2007, I have made an application for grant of quarries. 2007, my lord, that they have rejected my application.
When rejected?
Kindly, I'll show the documents. My lord. Kindly see annexure E in page number 90.
27th February 2007.
Yes.
When rejected?
27th
Please, my lord,
February.
please, if you are arguing, I'll sit. Otherwise, don't confuse. I'm competent to make submission.
Please, since your last.
Please, I'm requesting. If he is arguing, I'll sit, let him complete. Otherwise, my lord,
Just I am
I'll-
assisting the court by
yes,
saying that.
annexure A in page number 15, because this confusion to set right, then it will take time. Therefore, I'm humbly request.
Council is only trying to demolish your confidence.
Kindly see in page number 15.
Hold on your confidence.
In page number
So when it was
15.
rejected? When it was rejected?
I have made application 1/3/2007. My application has been rejected by virtue of a rejection order in page number 23 dated 29th May 2007. 29th May 2007.
29 May
2007.
2007.
Immediately, I have approached revisional authority by filing revision petition. That is, my lord, kindly see, that is dated 29/5/2007 at ink page C, in page number 26, my lord. Order sheet that I have produced. And I have produced all the documents. And my lord, kindly see, ultimately, my lord, 2007, my lord, I have filed. Revision petition came to be disposed of on, my lord, 7/11/2023. In page number 73. They have taken 17 years to dispose of this revision petition. Holding that, as on 2016, what your lordship absolutely I accept. Holding that as on 2016, your application is not pending. My revision petition, my lord, I have challenged that they have said, my lord, in the rejection order, that is overlapping. And that quarry lease 1036 has been closed. I have approached this honorable court, and this honorable court has decided that subsequent to that demand notice, kindly see the order, which 17, whether in, my lord, as on the date of rejection, whether they have anticipated 2016 amendment, no.
You are relying on some amended rule.
No, I am not, my lord, insofar as rejection is concerned. My rejection is concerned that 2007, as on 2007, prevailing law is applicable. 2007, my lord. Rejection order is on the ground that there is an overlapping. Kindly see. In page number 24, translated copy. While considering, can I read, my lord? In page number 24, 23 is the original order. 24 is the, my lord, translated copy.
And it was already granted to the third party.
Therefore, that is, kindly see, that is closed. That is, kindly see in page number 55 on F. This is one Rajendra, K. Rajendra. He, my lord, has applied. His application rejected. They have even raised 2009 demand notice. Even after closing to the demand notice has been issued, we have approached this honorable court in this order that they have admitted it is closed. No overlapping. And these documents has been produced before the revisional authority, saying that QL number 1036 has been closed. What is closed? That quarry is over. What they are saying is 1030 QL number 1036 is overlapping with the applied area. This 1036 has been closed, and subsequent to that, even closure demand notice has been issued to that Rajendra, and Rajendra approached this honorable court. This honorable court has directed that there is no dispute regarding closure of that whatever they are claiming, that overlapping of 10th QL.
Which is that rule you are relying on?
53, rule 53, my lord, is the revision petition which you have filed in the year of 2007. Rule 53. Amendment, which 2012-8-2016 amendment is 8(2)D. Amended. That they have referred now. Here, very short point for consideration before this honorable court is whether the reason assigned while rejecting, whether there is an overlapping is the one point, and rejection can be considered of 2016 Amendment Act during the pendency of revision petition. This is the only consideration, my lord, before your lordship.
What do you say?
Amended. Because this is amended book, my lord, that they have given. That is prior to, my lord, amendment. 2016 amendment is not there, I think, in that book.
Let us consider their stand. Yes,
Please.
The application of the petitioner is dated 25/5/2007. At the time of filing the application for the area of 2 acres, that area has already been granted to one Rajendra. Initially, we rejected this application since it is overlapping with the granted area to some other person, that is Rajendra. Subsequent thereto, several renewals has been made in favor of Rajendra. He has conducted quarry. The very reason for rejection is it is overlapping. Now it cannot be revived. Due to the amendment 2016, no lease can be granted.
which is the rule? Refresh us, which is the rule?
But the 8 Rule 8B.
Rule 8B.
Yes. Rule 8B1 says, all applications received and pending for grant of lease or license prior to date of commencement of Karnataka Minor Mineral Concession Rules 2016 shall become ineligible, including the applications received for grant of mining leases of the minerals that are classified as minor minerals. Then, Lord, since we have rejected in the year 2007 itself, the reason is this. This is overlapping. That area has been already granted to Rajendra. Now in the year 2024, there is a clear direction. It is the intention of the legislator also that all the mineral concessions shall be granted through public action. Now the question of reviving 2017 application, which is filed in respect of an area which has been already granted, does not arise in the year 2024 is my submission.
Kindly see in page number 48, which we have in the revision petition itself, that we have taken clear stand, there is no overlapping, and 1036 has been already cancelled. And those documents, my lord, that we have applied, and we have taken, there is no awareness. And my lord, by holding 17 years revision petition, now my lord, that by virtue of 2023 amendment, by virtue of 2016 amendment, my lord, that I cannot claim, they can't say. Within, my lord, 90 days, they should have disposed of my application. They have not taken consideration, order sheet that I have produced. 2007, my application, my lord, revision petition was pending, and they have not taken any action. Even order sheets I have produced.
There was no application of yours pending.
Please, my lord.
Any application was pending?
That is revision petition under 53. Application, my lord, that
your application was rejected.
That has been challenged under 53.
That's correct.
That is pending, which they are not, they can't dispute.
Mere challenge will not revive the mere challenge will not automatically.
No, it will not revive. Yes, my lord, what your lordship says, my lord. In case if they have taken wrong contention, saying that this is overlapping, to cheat or to reject me, because, my lord, that they have, my lord, 17 years that they have taken. Once, my lord, we have challenged under 53.
my lord, insofar as my application is concerned, till 2023, that, my lord, whether application pending or not, appeal is pending. And, my lord, they are under consideration.
What difference will make that it remain pending for long?
That is, my lord, that they have to answer.
So what?
They have to answer. If at all, I am coming before this court, pendency, my lord, or revision authority, that is authority under the act, if they are saying that, my lord, kindly see order sheet that I have put, they have not considered because I have not personally looked after.
Long delay by the revision authority.
17 years delay.
How it will be helpful to you in this case?
My case is as on rejection, if your lordship, the ground which they have taken on 2007 rejection, if I am able to establish before your lordship that there is no other overlapping, then, my lord, I am entitled to, my lord, set aside that from your lordship. I am entitled to set aside that rejection order, then let them consider.
My submission is, on the
As,
date,
as on that date, 2007, they have taken a contention saying that this is overlapping. And, my lord, if at all, I am able to, I have taken that contention, that writ petition copy, that order has been produced, and, my lord, that reject the cancellation order, which 1036, which they are saying overlapping. That copy, my lord, that we have taken that specific contention, if I am able to, let them produce those documents, is saying that as on 2007, there is a 1036 lease is overlapping with my application. And let them give an explanation before this honorable court why they have taken 17 years. If 61 day that I have approached the revision authority, my lord, they will say, no, we can't consider. This is also court. This is appellate authority.
may I make a submission? As on the date of filing application, it is an admitted fact that that area has been granted to Rajendra. Now, their contention is, since Rajendra's,
He says that if we set aside the revision authority's order, then everything will revive for him.
Yes.
that will not revive.
How?
Because, my lord, the revisional authority's order is that, my lord, they affirmed the order of the competent authority saying that this has been granted to Rajendra for the area which has been already leased out. No application is maintainable.
But the notice
I
page
can't
55, page 55, some petition by Rajendra, page 55, annexure F. What is that? Some order was passed by this court in relation to that overlapping?
No, my lord.
No, para 6 of that order clearly says that demand notice has been issued in the year of 2010. He has the, my lord, insofar as, my lord.
Let me submit. This is the petition filed by Rajendra, who was a leaseholder of this particular area. And he has challenged, my lord, some demand notice, my lord, dated 21/2/2019.
So differently, entirely different.
Entirely different. He was running a lease, quarry lease in that particular area.
No,
the question of entertaining an application for the area which has been already granted to Rajendra does not arise, is my submission.
Kindly see para 6.
You filed some reply. So that whatever we pass the order is it?
Please, let them file, because I'll also, my lord, insofar as, my lord, this honorable court has considered 2009 itself, that quarry lease has been closed in the year of 2007 itself.
If you are seeking the benefit of Rule 8B,
please,
then it is extremely difficult.
Please, my lord.
Then it is very difficult.
No, in case I am able to succeed, that 2007 order is, my lord, that is set aside. I will establish that I am entitled, everything will be revived, and, my lord, my application has to be considered. That I'll make. There are several orders of this court.
There is no,
and
no provision in KMMCR Act for the area which has been already granted.
That is what I am saying. There is no existing quarry lease as on that rejection. That is what we have taken contention.
Date.
Our learned advocate, Mr. Bhat Ganapati Narayan, for the writ petitioners. And learned government advocate, Mr. Mahindra, appearing on service of the copy of the petition in advance. Notice returnable on 20th June.
Much.
Affidavit in reply shall be filed on or before 12th June. Rejoinder affidavit, if any, shall be filed before 20th June, before 19th June.
Much.
So on that day we'll take up.
Please.
Matter pertaining
It
to
is covered in that deemed conversion of.
matter covered by the judgment of this honorable court produced at the next page number 14.
Page 69.
Last but one page.
Covered.
Covered.
Which page? This is seal number 15. That conversion.
Yes,
Deemed
95-9.
So earlier we directed the authority to take decision on the.
Yes, as per this order, the order which is produced along with the writ petition.
Page.
Page 40, annex ream.
Page 40. Relevant portion is,
We also pass similar.
yes, only thing, date of the application in this case is
12th March.
12th February 2020.
Instead of 31st March, August, 12 September,
12th February 2020.
12 September,
No, 12th February.
12 February, 2023,
24.
24.
One sentence has to be added, that if the application is not decided, if they have already decided not, then they will be having a remedy under 49.
It is already there in this order.
Under 49, rule 14. So 15, heard learned advocate Mr. Shivali, please, S. Vallappa Gowda for the petitioner, and learned government advocate Mr. Mahindra for the respondent state and its authorities. Participated in this writ petition is to direct respondent number 2. That's the Deputy Commissioner, Belgavi District, Belgavi, to consider the application of the petitioner dated 12/2/24. The application came to be filed, the said application came to be filed by the petitioner seeking deemed conversion order in respect of land bearing survey numbers 46/1 at measuring 3 acres and 20 gutas situated at Marikate village, Bail Hongal, Taluk, Belgavi district. From under section 95 into bracket 9 of the Karnataka Land Revenue Act. Also, the petitioner thereby seeks conversion of the land from agriculture to non-agricultural purpose for carrying out the quarrying operation. In support of the prayer, from a learned advocate for the petitioner invited attention of the court to order of the division bench of this court dated 30th October 23. In which certain directions were received. First of learned government advocate could not dispute that the paid order was passed in the background of similar set of facts in the prayer. Full stop. In view of above, learned advocate for the petitioners produced yet another order dated 23/4/23, passed by the division bench of this court in writ petition number 9128 of 24 on the same lines, paragraph in view of the above. The present petition is disposed of with following directions. One, the petitioner shall submit the documents which may be necessary to be filed for consideration of application dated 12/2/24, stated to have been made by the petitioner to the competent authority. Full stop. Such documents as may be required shall be filed within a period of 2 weeks from today. Then two, respondent two deputy commissioner shall consider the said application dated 24/2/14, 22/4/24 of the petitioner, along with the documents which may be submitted in accordance with law. Full stop. The petitioner shall be communicated. Three, the amount payable for the purpose of conversion in accordance with Rule 107 of the Karnataka Land Revenue Rules 1966. Post of after the petitioner next pays the fine amount as required by the authority, as may be required by the authority, comma. Order of deemed conversion shall be passed by the authority. The subsection 9 of section 5 of the Act. Next, upon conversion is permitted, the petitioner shall be entitled to use the land for non-agricultural purpose, paragraph. While it is provided without number now, it is provided that the above direction shall operate, provided the application of the petitioner is not already decided by the competent authority. If the application dated 24/2/24 is already decided, already considered and decided, and the petitioner is aggrieved by such decision, comma, the recourse in form of appeal will be available to be adverted to in accordance with law and on merits, comma, for the petitioner. Present petition is disposed of accordingly.
Non-agriculture purpose only for
Quarrying operation.
quarry, lease and crusher.
Non-agricultural purpose, namely
Lease,
quarrying activities or the stone
Crusher.
crushing unit. Stone crushing. So this is specifically for that purpose.
yes,
Rule 95(9).
95(9).
Quarrying and crushing.
So you will convert all agricultural land into quarry lease by this law. Everywhere will grant.
If there is a mineral resource only, my lord.
No agriculture.
Number 16, Mr. Ganesh Kumar K.
Petition, my lord. Writ of mandamus, my lord. Is called by
What is
judgment, my
it,
lord.
16?
Seeking writ of mandamus, my lord, this is covered by the judgment of this honorable court. It's covered.
Oh,
Yes.
by which page?
No, my lord, sorry. Submitting, my lord. ZC, my lord. Part. Application.
Covered means the direction to be issued to decide the application.
Lord, here one more interesting prayer is made. First prayer, they are seeking direction against the authority to stipulation.
In particular, to grant, no, that is no such prayer to be granted, only for consideration.
For obtaining
You are
the.
praying that the
Render no objection, Lord.
No, please, that
No-
part will not.
No objection, a decision, we will take a decision within a stipulated period, there's no
Please,
problem.
please.
2 months time may be fixed. 2 months for the authorities. Thereafter, we'll take the decision.
Public.
Two months. 2 months.
2 months for the authority to render no objection or whatever.
No, that part will not.
Writ appeal matters, number 17. Mr. Muralidhar HM.
Here for the appellant.
Hearing for the government, my lord.
There is a delay of 26 days. perhaps.
So before Lok Adalat, who made statement?
Please, my lord.
Some statement was made on in Lok
Yes, my
Adalat.
lord, this is a third round of litigation, in fact. The order is firstly, there is a delay with regard to the challenge to the acquisition. Secondly, my lord, when the land vests with the government pursuant to the preliminary and the final notification, the restoration of the land does not arise. So therefore, the Honorable Learned Single Judge has rightly at page, the relevant page, my lord, 51, internal page 20, the Learned Single Judge goes into all these aspects.
My lords, I give facts, my lords. I'll give the facts. Now, the preliminary notification is of the year 1988. The notification was issued invoking section 17 of the Land Acquisition Act, that is urgency clause. When urgency clause is invoked, the compensation 75% would have been remitted, that was not paid. And the final notification was issued on 19/1/1989. The award was passed on 10/5/1990. Well before the passing of the award, without paying compensation, possession was taken on 24/7/1989. A reference.
You can't reopen all these things.
Yes, I will come to that, my lords. Now, the only question that arises for my lord's consideration is, though section 17 was invoked, the land is not utilized till date.
That is also no ground to.
And compensation is not paid as ordered in the Lok Adalat.
Correct.
Even to this date, the compensation is not paid.
My lord, that is
Even to this
incorrect.
date.
Compensation is not paid.
No.
It's been paid.
Executions are pending.
This is the third round of litigation, my lord. My lord, if your lordship sees at page 352, that is the order reflected in the Learned Single Judge dated 22. Therein, my lord, the question was for enhancement of compensation. That was looked into page 352, my lord.
Page
352.
350.
That is the order dated 24th March 2022 of writ petition 11372 of 17.
This is the order which my learned single judge has extracted in the order.
Please, that it has reached a
Yes.
finality.
Yes, the order passed in the Lok
Set
Adalat has
aside
reached
the
finality.
judgment and the award.
They dispossessed me from the land in the year 1989. And yes, I raised reference. Compensation was enhanced. And the matter went up before the Lok Adalat. Lok Adalat fixed the compensation with a direction to pay the compensation within 8 weeks. And I went before the Lok Adalat again complaining that the compensation is not paid. And I was driven to execution. Execution petitions are still pending, and even now they have not paid the entire compensation.
Compensation at the rate of 2,48,000 was awarded.
It was
And then-
modified to 2,20,000. There is no dispute regarding that. The dates and the orders passed earlier are not in dispute. My respectful submission is the non-payment of compensation entitles me to challenge the acquisition on the ground of irregularity. Irregularities are two. That is non-payment of compensation. Number two, there was no necessity to invoke section 17. The very fact that they have not utilized the land till now.
So the section 17 argument must have been raised in the initial.
Please,
Pardon?
Concluded.
That's
Then Lok
concluded.
Adalat consent award.
please.
No, it
there's a
was not a
joint-
consent award, and nevertheless.
Lok
since-
Adalat award.
Lok Adalat is, yes,
It was
yes.
regarding enhanced compensation.
Enhanced which is not paid.
There's
a
also a
different thing.
joint memo with
That
regard.
will not furnish you a ground to challenge the entire acquisition again.
Lord, the meaning thereby, now neither I have the land nor the
Are you
compensation.
not paying compensation?
My lord, the compensation as far as I need to get my instructions, but from the reading of the papers, my lord, this compensation has been arrived at by virtue of a joint memo of both the parties, and that is,
That is right, but the grievance is that it is not being paid.
on that aspect, let me find out as to when it was paid, because this is a matter of 1990, the award.
May I submit, my lords?
But
Three batch of
however,
writ
on the
petitions were
merits of
filed.
the case, my lord,
3 batches are filed, and against which 2 other writ appeals are pending, my lords.
Here, what is the prayer? What is the prayer in the writ petition again?
quashing
Quash the
quashing of the
notification.
what?
preliminary notification and
Notification.
final
That was already
notification.
a prayer. That was a prayer already made in the first round of the
No,
thing of the acquisition. Was
And that
also a
has-
prayer made.
no, that is for the first time I challenged the notification.
No, this prayer is not for the first time. This prayer was made in the earlier petition, which went up to the Lok Adalat.
Yes.
Consent award
No.
relating to.
The matter
enhanced-
went before the
enhanced
law.
compensation was passed.
No, no, no.
You are saying that the compensation is not paid, and therefore you are challenging. the
No,
compensation.
the matter went before the Lok Adalat like this, my lords. I
Yes.
filed an application under section 18 before the reference court. The compensation was enhanced to 2,48,000, against which they came in appeal before this honorable court,
So at each
challenging
stage,
the enhancement, and the matter went before the Lok Adalat. The enhancement was reduced to 2,20,000. That is how. It is not that earlier I challenged the notification.
That's correct. But in any case, you already lost your locus to challenge the acquisition. Having
My-
gone through this, all this.
My lord, my respectful submission is, I was thrown out of the land without paying compensation, though law mandates that it should be paid before taking possession. All right. How long, my lords? Now if they pay that, even now they have not paid.
Possessor is taken.
possession is taken. my
Possession has
lord.
been taken
Possession has been
by,
taken.
by operation of law.
So find out why compensation is not. paid.
I'll find out with regard to the compensation, my lord. All this has been appreciated by the learned single judge, and the learned single judge looks into the aspect that first round of litigation was only to the challenge to the award. Then they devise a plan of challenging the preliminary notification and the final notification after 30 years. So therefore, on merits, my lord, this writ appeal would not survive. With regard to the compensation, I will get my instructions and submit.
May I request my lords to post this matter along with these 2 writ appeals.
The writ appeal at.
Writ appeal
serial
number 460 of 2023. And another writ appeal is listed today at serial number 54, 498 of 23.
What is that?
Same,
That is also the
similar.
same preliminary notification and challenge
Yes.
to the same notification.
Yes.
And same learned single judges.
So
also.
you are not paid enhanced compensation or no compensation paid?
Enhanced compensation is not paid.
Enhanced. Otherwise compensation is paid.
Pardon, lords?
Otherwise, the compensation as originally fixed is paid.
Originally fixed is paid beyond that period of time fixed in the statute.
That is a different thing, but paid.
Yes.
Therefore, that you may have a different remedies. You find out about this.
Please, I'll,
So that court would like to ensure that the amount is paid
please, my lord.
before we go to the merits of.
Please,
When you.
next week. Yes, ma'am.
Next Monday.
Next month,
Much
along
obliged.
with those writ appeals. my lords. Those two writ appeals. One is today at serial number 54, 498 of
All on
23.
next Monday. All three on next Monday.
Yes, and 460 of 23. 460. Please, my lords. At least if I'm not able to get my lands back, my lords, because of the delay, compensation can be paid as per 2013 Act.
Just find out about compensation.
Please,
And it will solve everything.
please.
You filed execution.
Pardon? Executions are pending since more than 10 years.
That is also not, I don't know about whether it has arrived at any file.
So that is the.
That is
pinching.
pending in the pleadings.
What pinches in the shoe is the compensation.
Please.
It is. Next Monday.
Please, my lords.
You consider.
Injustice is caused to me because at the time of driving me to the execution court, because this is a statutory lapse.
While considering the merits of the controversy with the help of the learned counsel for the parties, it transpired that one of the aspects of the grievance of the of the appellant is about non-payment of the enhanced compensation awarded and agreed before the local adalat. Full stop. I propose this from a learned government, the additional government
Advocate, my lord.
additional advocate general,
No, additional government advocate,
additional government advocate Miss,
Shweta Krishnappa.
sorry, Sweta, so and so. Six time to take instructions on that count. In view of the request forthcoming from both the sides. The petition shall be listed on Monday,
Please,
that is on 3rd June,
please.
24 at 2:30,
Yes, ma'am.
as per your request.
Much obliged.
Shall we issue notice?
Please, my lord.
So notice, we will serve by next Monday. You are appearing for whom?
Respondent 1, 2, 3, my lord.
1, 2, 3. So
And the
defense
central-
state officer,
And 4 to 6, 4 to 5
the
is the central government.
additional government advocate, so and so, accept notice on behalf of this number 1, 2, 3. Full stop. As far as the rest of the respondent are concerned, learned advocate for the appellant is directed to serve copy to learned advocate who appeared before learned single judge. Give copy.
Yes, I will serve.
Who is directed to appear on the next day. That once you take the instruction.
Please, my lord, and call along with the other writ appeals. Other writ appeals connected to this.
Along with officers. So next Monday we'll take.
Please.
So number 18. Chandrasekhar PV.
I'm appearing for the appellant, my lord. The first respondent received the compensation in 2016, my lord. After 8 years, he made a representation to pay the common suspect of 1 gunta of Kharab land, but that was rejected by way of endorsement. Leonard Singhal Judge relied on the order of the Leonard Singhal Judge of Dishonorable Court that has been stayed by division bench of Dishonorable Court, my lord, in writ appeals, my lord.
But this petition is pending. Petition is pending.
Petition is pending, my lord. Yeah, so far as one survey number, it is followed up, my lord. Second survey number, it is pending, my lord. So for annex D, my lord, the lordship kindly say, there is no interim order also in the writ petition. Still directed to pay, proceed with to pay the compensation.
You are not admitting that this land, surrender is Kharab land.
No, that is 72/1.
It's not a Kharab land, according to you.
No, it is a Kharab land, my lord. It was rejected. That was questioned before Dishonorable Court by relying on the order of the another Leonard Singhal Judge. That has been challenged in writ appeal. Writ appeal also stayed by Dishonorable Court. Interim order is granted. They pass on copies. And in so far other 13 guntas is concerned, that's it's still pending because Leonard Singhal Judge permitted to file objection to the government. And there is no interim order prior in the writ petition also.
Who are you? Authority?
Yes, madam. They received the compensation by way of consent in 2015. After 8 years.
A is not classified as Kharab land.
Please, my lord, this is Kharab land, my lord. And the contention of the KIADB is that Kharab land, due to a government notification, if it is not granted in accordance to law, then you cannot seek for compensation. And in this case, there was no grant made in the name of the petitioner.
So you are supporting them?
Yes. The Leonard Singhal Judge relied upon the order of Dishonorable Court in WP 1065.
The challenge in this writ appeal is directed against order dated. What is the date of the order?
24th July 2020.
Where is that?
It's page 11.
24th of July 23. Passed by Leonard Singhal Judge in writ petition number 12386 of 2023. The dispute is what is the prayer in the main petition?
The main petition to quash the endorsement issued by the KIADB rejecting their claim for payment of compensation of 1 gunta of land.
Compensation.
Yes, ma'am.
Full stop. The prayer in the petition was with regard to the grant of compensation in respect of Kharab land. Full stop. The order, it is true that order dated 24 July 23 impugned in the present appeal is interim order and the proceedings are pending at large before Leonard Singhal Judge. It could be immediately noticed that the following directions of Leonard Singhal Judge in the order have the finality of have the trappings of finality. Then quote this portion, needless to state that page 12, needless to state that up to A Kharab land. Learned counsels for the appellant submits that even if A is Kharab land,
yes,
unless it is granted to the applicant, No compensation shall be payable. Full stop. In the aforesaid view, notice to the respondents, returnable on 24th June.
R2 is a government, my lord.
R2 is the government. I'll take notice to R2, my lord.
Learned additional government, so and so takes not, accepts notice on behalf of respondent two. Full stop. The above quoted direction, the above direction of learn a single element state till the next state.
Delay, delay.
If the delay is there, then difficult, only notice.
Yes, delay.
No interim state.
Delay.
That's number 19, Mr. Srinivas K. Hearing for appellant. Madam.
My lord, the learned counsel for appellant has requested me to seek a week's of time.
Is
my lord.
that Nikanti or what?
Nilkanti.
So when the group is 18 June,
Nilkanti Ramalakshmi.
notice on 18 June. Other, the entire group is kept on 18 June.
May be connected with
And,
writ appeal number.
what is your good
210.
name?
Sarita Kulkarni.
We have accept notice on behalf of the government,
Please.
state government and its authorities. The rest of the respondents, any respondents are there?
Yes.
Private respondents are there?
My lord,
300.
Private respondents shall be served.
much of- Please, sir.
On submission, it may be connected. Writ appeal
You
number
will go,
210.
you will go with the group.
Please.
He is aware. The
Please.
court officer is aware about number also.
Number 20, Mr. B.C. Prabhakar.
I appear for the appellant, my lord. My lord, the only question that would arise for your lordship's consideration is whether the learned single judge is justified in directing the National Aid Bank, where public appointments are made, to absorb temporary employees as permanent employees right from the date of their entry. My my endeavor is to convince your lordship that the direction given by the learned single judge is contrary to the dictum laid down by the Constitution bench in the case of Umadevi. My lord, three reasons are given by the learned single judge. One, there is a legitimate expectation. My lord, in the case of temporary employees, my lord, the order itself would state that the nature of appointment is temporary. They knew the consequences of their terms and conditions of the appointment.
They were subsequently interviewed or not?
My lord?
They were taken as, they were supposed to be treated as regular employees.
No, my lord, that is not correct.
It is there.
I will convince your lordship.
Appointment letter itself, page 22.
They were taken as temporary employees. And in one of the appointment orders.
Your permanent absorption in the bank is subject to your being found suitable in the interviews. Whether those interviews are taken?
They were not interviewed.
Why?
There was no vacancy. There was no sanction for branch manager has issued that letter. Branch manager has issued that letter. My lord, the settled legal position is even if the person is selected and he is in waiting list, he cannot have any legitimate expectation.
So
Therefore,
understood, but what is the grievance now in respect of this direction?
my lord,
What is the grievance now?
grievance now is, well, they are working, still they are working. I have accommodated them for regular pay scale. They have not been absorbed because there is no sanctioned post. I could have terminated them in the beginning itself. The litigation is pending right from 2009. That's why then the case is pending, my lord. I have only two sub-staff. There is no sub-staff now. That's why, my lord, though I could have terminated them, I did not terminate because the pendency of the writ petition.
So you are aggrieved by the direction to regularize them from particular date or in general?
My lord, in general, my lord, in general, I am also aggrieved by particular date. Any absorption, even assuming that they are eligible for absorption, it must be from a prospective date, not from the date of their entry.
So are you ready to absorb them as and when the vacancy is available?
Now that instruction I will take, my lord.
So you must be clear when you are challenging the order. Are you aggrieved by the entirety of the order Or you want them to be treated permanent from particular date and not from the anterior date?
That instruction I will take.
Who take?
I will take that. Yeah. We let it be
How
called.
how many employees are involved?
Only two are there.
Then you take
I will take instruction. On that question, I will take
some
instruction.
sympathetic way of.
Very well, man, very well. I'll take instruction.
So we'll keep whenever you want.
Next week, man.
Next Tuesday,
Next Monday, man.
next Monday.
Very well. Much appreciated.
Number 21, H. Muralidhar.
Delay is the.
There is a delay of 66 days. The order of learned single judge is, I think, page 10.
All contentions are kept open.
Yes, my lords. But the estate officer has no jurisdiction. That was my
That
case.
contention is kept open by learned
Yes,
single judge.
Contention is kept open.
Then what remains? Why should we exercise the appellate jurisdiction? And everything is kept open.
No, if I have approached this honorable court on any other count, that would have been fine. But I approached this honorable court on the ground that the Public Premises Eviction of Unauthorized Occupants Act has no application.
That is also kept open. Everything is open.
Even if the
From sky to earth, you can argue anything.
now an authority passes an order which has no jurisdiction.
Or you want to argue from earth to sky, then also you can argue.
In other words, the learned single judge has driven me to a forum which has no jurisdiction to handle. That is the thing. And the judgment relied upon by the learned single judge has no application because that was a case where the government was the lessee and the landowner sells the house to somebody. And in that circumstance,
all the questions are kept open, my lord. And
that is what we say, therefore you say.
Yes, the public premises, it is a public premises, my lord. The land was acquired for the purpose of laying the road, laying the railway line. And that particular area is required for us, my lord. For that reason, notice has been issued. There is a encroachment by them for that reason.
Encroachment.
Why they are saying that it is not, act is not applicable?
They say that, my lord, there are disputed questions are there, and that has to be decided by the civil suit, by way of a civil suit. And they are relying upon one particular judgment of the Supreme Court.
That you better take before the competent court under the Eviction Act.
No, now the present.
It be a matter of evidence.
My lord, that particular judgment has no application for this particular case. In that case, my lord, in Supreme Court, the Union of India had given an undertaking that they will approach the civil court.
Public premises.
Central Act.
Not this, 71. 70. See, Karnataka. This is what key. Public premises.
Central
Eviction
Act.
upon the register of people's act 1970. Today, what is the ground position?
My lord, they have filed the objection, my lord.
No, ground position there in relation to land.
In that particular portion, my lord, they have put up the construction, my lord.
You are for railway.
I am for the railways.
No, my lord. The certain land was acquired by the first appellant, Housing Society, for formation of layout. The layout was formed, site was allotted. One of the purchasers were appellant number 2 and 3. Allotment was made long back, construction was made, and they are living there. In the meanwhile, what happened? The railways sought acquisition of a portion of the land which was earlier acquired in favor of the appellant society. Yes, a portion of the land was acquired and they are in possession of the property. But what they are now doing is the sites which are allotted by the first appellant to the appellant number 2 and 3 is the one which is also acquired by them. That is their case. And we sought joint survey. See, a portion of few guntas of land which was acquired for railways comes adjacent to the land which is allotted to the appellants. We sought for joint survey. If it is coming under your acquired land, then it is okay. But they are not prepared for that. And treating that this as a public premises, saying that this portion was acquired, they are coming on my property by using method of summary proceedings under Public Premises Eviction of Unauthorized Occupants Act.
It is your own private land.
Yes, I purchased from Housing Society to which the government acquired and handed over land for formation of layout long back. And definitely this is not the piece of land which was acquired subsequently for railways. And the allegation is that of encroachment. Encroachment, allegation of encroachment cannot be gone into in a summary proceedings under Public Premises Act. Kindly turn to ink page 135.
Then they can proceed with the acquisition. Here you can't have objection except on the legal ground. Can proceed to acquire your land.
Yes.
Only objection on your part is the use of this provisions, eviction provision. So anything to show There are two petitions.
One petition,
The original petition.
one,
One,
yes,
society.
society,
The-
yes,
you
allottees.
sold the land to private person.
Yes, members of the society.
No, no. The transactions which took place in 2003,
Yes,
possession certificate,
yes, was issued.
number one society, yes, allotted site number 448,
Yes,
you said layout.
was the original one.
26, 197. 33, 27. Right, the exhibit sale. Inner favor. Certificate, Mandula sold the road.
Appellant number 2 is the subsequent buyer. Appellant number 3 is the original allottee from the
How
society.
did you become owner?
Yes,
In what way? Purchase from?
purchased.
From?
Pardon, my lords?
Purchase from?
Purchased from the original allottee. Original allottee. First appellant society is a housing society.
But the original allotee is already transferred the land.
Transferred the land to me.
So then how could you purchase from the original allotee?
Can. It is like any other allotment, my lords.
Five. Paragraph 5.
Lord.
Paragraph 5 of your petition. If you are able to establish your private title, then you might have case, but for that you have to establish.
My title.
Paragraph 5, read it.
Yes, I have sale deed with me.
Read it, kindly read it.
Which paragraph, my lords?
Paragraph 5, page 24 of your original writ petition.
Yes.
You have to show your title,
Yes, my lords.
trace your title.
Yes. My lords, the second appellant sale deed. Manjula's sale deed is at think page 68.
So you are utilizing 448 or 449?
448. And my sale deed,
Your
Is-
sale deed is in 440, in respect of 449.
yes.
X are not that.
Lord,
Please to us.
one second. Manjula to Yuvaraj. My 68 is my sale deed. Yuvaraj in this writ petition is appellant number 2.
So they are utilizing which land?
Pardon, my lords?
The railways are utilizing for acquisition which land?
448.
Where is the notice?
One
My lord,
second.
that is at page number 95, my
My
lord,
lords,
annexure
first-
W.
Notice under the-
Yes, yes, my lord. Page number 95. It is issued to one Mr. Suresh, my lord, who is not a, before my lords, who is not the,
Issued to one.
Mr. Suresh.
Where is the name?
His name is, my lords can find at top, my lord, after 3 paragraphs. Sri Suresh, house number 448.
95.
Yes, my lord, page number 95, annexure W, my lord.
Site allotment certificate.
No, my lord, in my compilation,
No,
it is
I will come to that.
the public notice, my lord.
May I submit, my lords? Appellant number 2, Yuvraj, title, page number 68, site number 448.
440.
Yes,
Your sale deed directly in favor, your favor is in 449.
now 449 is Krishnamurti's, which my lords would get.
Be on your government, we do not know anything. Paragraph 5, page 24, you said that 448. Belongs to somebody else. In the next paragraph, you are saying that 449 was purchased by society, is number 1. So your title is directly traceable to 449. What is the subject matter of notice is 448.
It is submitted that the petitioner number
Subject
one
matter is-
society has allotted site number 448, measuring east to west so formed in the layout so in favor of Manjula. The copies of the allotment letter
My lord, as per my compilation which has been given to me, that is 95 and 96, my lord.
448 was
If-
allotted to Manjula, annexed
What is the
D.
date of notice?
Yes, my lord. Date of notice is that, my lord, 24th November 2022, my lord.
Page 132.
131 and 132.
Then, my lord, the petition filed by us is available immediately after the notice, my lord. Then, my lord, their objection,
448, house number 448.
448 and
Yes.
449, my lord.
449.
Yes, my lord. The notice has been issued to, with respect of 2 premises, my lord. That is 448 and 449.
Then we'll issue notice. 449.
Then, my lord, the objection, my lords would find, the objection filed by the appellant at page,
Both properties in any case are private.
my lord, there may not be the private property, my lord. The reason is that, my lord, I will explain, my lord. Preliminary notification was issued by the government of Karnataka for the laying the railway line, my lord. Then the appellant number 1, who is before my lords, he participated in that particular acquisition proceedings. He received the compensation and the area was also earmarked. That particular area is for the railway development, my lord, that is available with the railway. Subsequently, my lord, that particular area has been acquired by them. That has been, they are in the unauthorized occupation. And in the event, my lord, if this particular area is not taken as, then it will affect the entire project, my lord. And in the notice, we have specifically mentioned for what purpose this particular area is required and why it is a public premises. And entire narration has been given, dates and events have been provided, and sketch is also annexed with the petition, my lord. And area is also mentioned. What is the area they have encroached upon? And the survey number is mentioned in their allotment letter, possession certificate, my lord. Very same number, survey number has been mentioned.
So it was a railway line.
Yes, my lord, it is a railway line.
What way railway?
For the purpose of expansion, we need this particular area. my lord.
How it become railway line at this stage?
My lord, it has been acquired and it has been given to us, my lord.
Required.
Yes, my lord, acquired. That is a statement which we have made in our petition, my lord. If my lords look into the petition, my lord, I have specifically narrated the events, a collection of the award amount also by the appellant number 1 who is before my lords.
Appeal you have taken.
Yes, my lord.
There is it.
Yes, my lord. I request my lords to kindly take the petition what we have filed. I have not filed the objection. I request my lords to kindly take the petition which is available immediately after the notice. That is page, must be the page number 130, 132. The petition filed by the railways before the estate officers. Yes, my lord. That is a petition under section 7 of the Public Premises Act, my lord.
Page 133.
My lord, hope my lords has that particular page, my lord. In para number 2, acquisition notification I have mentioned, my lord. Then the Atmiya Gelegera Balaga is the appellant number 1 before my lords in this particular instant case. Then, my lord, I have mentioned the survey number, my lord. Then next paragraph, my lord, when we have identified that particular unauthorized occupation, what is the extent and all those things, my lord. Then the documents what we are producing, that is the sketch and all those documents we have annexed along with the petition, my lord. And it is a railway land. And my submission is that, my lord, that particular question is required to be decided by the estate officer. They have also filed the objection. If my lords take next document, that is their objection. The objection of the appellant number 1 is that the railway should have objected for the construction. That is the objection what they have made. I request my lords to kindly take next document, my lord. That is the objection submitted by the appellant number 1. Para number 9 is the objection, my lord. They say that railway did not object for their construction. Para number 9, my lord. Internal page number 3 of the statement of objection. And the learned judge, my lord, has observed that all the question has to be looked into by the public premises officer.
My lords may kindly see now. My acquisition of land was in 2002.
Because he is able to show now, prima show that it is a required land
Yes,
by the railway, and therefore it is public.
Yes. And kindly see, my lords. Kindly see page 133 for a while.
You may be right, but it is
Page paragraph 2.
it requires reading of evidence. If at all you are to if you are able to establish.
There, 5 acre 26 guntas was acquired for me in the year 2002-3. What they have acquired was subsequently as set out in paragraph 133 at paragraph 2. It is to submit that government of Karnataka by a notification dated to.
We are not interfering.
Yes.
W. Recoupage 181. Itself to be taken up.
Madhukar Deshpande. Respondent number 1, my lord.
Number 1. Additional government period.
No, my lord, it is a estate officer, my lord, is a.
Present writ appeal and the for of the Karnataka High Court. Dated 18 July 23. Prayers in the petition. The challenge was proposed notice dated 24/1. Issued by in respect of number 21, house number 4. Layout G+3F correct road. Comma is also to similar notice of even date issued to risk number 3, issued to petition number 3. Survey number 21, house number 449. AGB layout. They were the notices issued by the competent on the ground that respective petitioners had encroached the railway land to the extent indicated in the notice. State land could not have been subjected to encroachment in the public lands. As it did not become, as they were not, as the lands were not inward from our. As defined in the 1978 Act.
May I pass on this judgment also, my lords?
On the other hand, the learned that the land was already acquired in the year 2005.
Yes.
And became lands of the railways to satisfy the definition of.
Yes.
Learned single has not gone into the merits of the rival contention while disposing of the writ petition. Observing that since the petitioners have already entered appearance before the competent authority, whom I have filed the pleadings and the battle lines have drawn. All the contentions, including the jurisdictional facts. Under public and that the proceedings are pending to be taken. Full stop. The facts of the case and I will heard learned counsel to the party. And this court sees no reason, this court does not see any reason to subject to the order of Lawrence Single, who has kept all the, including the jurisdiction aspect, hope to be raised in accordance with law. No cases made out for it. It was without saying that.
I appeal for the
KV
appeal.
Narasimhan.
The office objections have been complied with, my lord. The office objections have been complied with.
But
My lord,
sort of,
the respondents have also preferred a writ appeal, my lord. Both the matters may be connected and heard together.
this is the plan. What do you want?
The respondents have also preferred a writ appeal.
Learned advocate for the appellant stated that the respondent has also preferred cross appeal against the very judgment impugned in this appeal. He requested that both the appeals may be listed together. Full stop. This appeal therefore shall be listed with the, which is the number?
699 of 24
Writ appeal number 699
of 2024.
of 2024.
4.
On which date?
Coming week.
Coming week.
Coming week.
Next Wednesday.
Great.
That will be 5th June.
December 23. HM Muralidhar.
Why don't you, why you are coming with all matters which are liable to be discussed?
My lords, in this case, I am not seeking change in date of birth.
You are seeking,
No,
let us,
I am only requesting them to correct the clerical error.
the same thing.
Oh, if I have given some document at the time of joining the service,
After 34 years.
all right, which contains different date of birth from the one which I had furnished and seeking to change the date of birth on some other reasons or order, I am wrong. It is a settled position of law that an employee cannot seek change in date of birth at the fag end of service. Learned single judge has proceeded on that ground only. Kindly see the document which I had produced when I joined the employment, which my lords would get at the ink page. Service register extract. What I had given was only my SSLC certificate, which my lords would get at annexure B, in page 41. My date of birth may kindly be seen therein. It is 1/12/1964.
Sorry, nothing.
One second, my lords.
After 35 years, you can't challenge your date of birth, or you can't get correction on any ground.
No, typographical error or clerical error can always be corrected.
Sorry, come with better matter. Dismissed. Yes.
Number 24 for compliance in contempt matters.
Next, we have filed the compliance affidavit, my lord.
May I request for 1 week, my lord? I am not able to contact the complainant, my lord. I request for 1 week. They say that this
We have
compliant.
filed the compliance affidavit.
Compliance affidavit, where is that?
Filed it on
Page,
6th
yes,
April.
compliance. What is the, what was the direction?
Lord's direction was to regularize.
Tell the
the
entire
service-
pension,
Regularize the service and pay the pensionary benefits.
regularize this service. You have done it?
Please, we have done it.
Page?
Page 16, my lord.
Page,
Affidavit filed by respondent accused, yes.
page 12, translated copy, my lords. By order dated 11/7.
Order dated 11/7/23, regulating services.
Please,
Then about pension,
pension, my lords, at page 17.
17. 17 is not available, 17, yeah. So pension order is issued.
Please, it's been dispensed.
I'm only requesting that I've not been able to contact the complainant, my lord. If at all my lord finds, or I may request.
You can contact the client with order.
Lord, I-
Tomorrow at 2:30.
Yes, much obliged.
Just get the, see the copy and so.
Yes, my lord, I will.
Number 25, should we honor?
For the complaint. The fourth respondent has filed their compliance affidavit, my lord. I may be permitted to file counter to that, my lord.
Counter?
Please, my
For
lord.
what purpose? What is the direction?
So the direction
After verifying the original register, mutation register, and
Please.
Sangu Ali chit register, pass necessary orders for continuation of the name. You pass that order?
Yes, sir.
Where is that?
Along with the compliance affidavit, your lordship will kindly
Let
see.
us see.
Next up, R1. And at page 10 is the translated copy, your lordship.
So who is the grantee of the land?
The grantee of the land and the, see, the lands are on the Inam Devolution Act. On the day of the vesting, the entire land vested with the state. The person in occupation has to file an
Your
application. for the-
government advocate?
Yes, sir.
What's your good name?
Jafar Shah. Jafar Shah.
Jafar Shah. So the direction is this.
Yes,
Go
sir.
to page 17.
Pardon me.
17 of the order of law and a single judge, which are the directions under contempt.
Yes, sir. Consequently, the register
After
disposal-
verifying the original grant
Yes,
register,
sir. Yes,
mutation register, and
yes, sir.
Sagu Ali chit
Yes,
register,
sir. Pass
pass necessary
to
orders
constable. Name of the
for
grant.
continuation of the name of the grantee.
Yes, your lordship.
So who is the grantee?
The original grantee here, lordship, this person, this applicant, and he has
Applicant.
sold the land in.
So
between.
whether you have continued his name in the register,
No, he has sold the land to subsequent.
we are not concerned. Then you challenge this order.
This land was re-granted.
Or you show that this direction is not capable of being compliant.
It says, after verification of the records, your lordship, you can kindly see that he has alienated the lands. Once he has alienated the lands, continuing his name cannot be.
Where is that? Let us. Because you go on passing long order, page 10.
Page 10, your lordship. On behalf of the Archbishop Bangalore, Sri K. Susaraj and Sri S. Santosh on 2110 submitting a petition to the Honorable Deputy Commissioner in Yalhanka, Taluk, Hesagatta, Hubli, Jodi Mavallipura village, and in the states, other districts, several lands are belonging to the Archbishop. And in the RTC of these lands, against.
They are the pious persons, they don't know law. Pious person don't know, we only know the law. They go on passing long order. You guide, what is the order? Let us see. What is the order? As per the order passed by the Honorable High Court, page 12.
Lordship,
And the instructions of the Deputy Commissioner, the petitioners on 21/10/20 submitted requisition mentioned land, so and so and so. Let us sold out the lands.
Yes, sir. At page 13, if you
Let us out the lands.
remaining
Sought
with
by the
regard to
petitioner
survey number
already several
135.5,
lands from J.H.B. Fernandez.
12
Several
gunters of land
farms.
is in the name of the Solur Church.
He is Fernandez.
Yes.
So this bishop changed the title of the land, sold the land. Where is
Yes.
it? Where is it?
The details of the transfer. Details of the transfer to different churches. That they have not filed along with the application. I will
How
check.
do
it.
you?
I will secure. A week's time I will grant it.
Have you sold the land? Bishop.
Yes. they have
Please,
sold.
my lord.
Okay. Mr. Bishop, you have sold the land.
No, my lord.
He is saying.
No, it's false. Because
Lordship, you kindly see page 30. It says remaining with regard to survey number 135, 12 gunters of land is the name of Solur Church. Again, it is name of different churches.
the Archbishop has assigned to the other subsidiary churches.
You are a church.
Yes, my lord.
Remaining with regard to Survey 135, 12 guntas in the
25
name of
gunters in the
Solar.
Ramnagara Church, Begur Church.
You all are together.
No, there is no any alienation by the Archbishop, my lord.
There is no alienation.
Yes.
But he himself is admitting that they have assigned. Now, once there is an order.
Assigned for
or
the
even
other
if-
churches, my lord.
Yes. even if
Because
it is assigned, where
all
does
the
the assignment-
churches come under the Archbishop.
Mutation entry.
That is what I just indicated.
Please.
Nobody understood. All are together.
We will get the entire copy of the mutation register.
To show the
Yes.
evidence of transfer.
That is.
The legal transfer is taken
We will get
place.
the mutation register copies to show the mutation effective and what documents.
Let him. When will,
A week.
next Tuesday. Write down the Archbishop. Diocese, DIOCESE, Bengaluru. Contended in his writ petition that certain lands were granted by the competent authority for the establishment of churches, and that in view of the computerization of the land records, the entries in favor of the church in relation to the said lands came to be erased and discontinued. Full stop. Learn a single judge while disposing of the petition issued the following directions. Paragraph 3, page 16 and 17. Paragraph after quoting, as per the above direction, which are sought to be complied with in this contempt petition, the competent authority was required to continue the name of the grantee in the land records. Full stop. While the paragraph, while the grantee church, while the grantee archbishop complains that the names are not continued, from a learned government advocate, Mr. Jafar
Shah.
Stated that the lands were subsequently transferred and new owners
Yes.
have come on record. Yes. Full stop. Learned government, additional government wants to produce material in support of this stand. Stand over to next. Stand over to 4th of June.
Number 26, Mr. Shekhar L.
I appear for the accused, my lord.
Complied.
I filed the compliance.
Which one? Serial number?
26.
26. Learned advocate for the contempt petitioner, Mr. Shekhar L. stated that the directions of learned single judge brought under this contempt petition are complied with. Full stop. Learned advocate Mr.
B.S. Srinivas.
B.S. Srinivas for the respondent confirms the statement. Full stop. Any of the above, the contempt proceedings are closed and disposed of. Notice is discharged.
Much obliged.
Number 27, Muhammad Muzasim.
This is that grant.
Counter-affidavit is filed, my lord. Counter-affidavit is filed, my lord. According to me, I have complied the order passed by the Lord Single Judge.
Last
Other side has not denied, my lord, the averments made in the affidavit.
last date, they were
There's some
under-
dispute about the payment of rent.
No, only regarding, my lord, rent. In fact, we sought details from the complaint, my lord, what is the rent agreement, at least it is not furnished.
My lord, seeking for a time, my lord. Senior counsel is out of country.
Pardon?
Seeking for adjournment, my lord. Senior
Adjournment,
counsel is
why?
out. Senior advocate is out of country, my lord.
Senior is out of country.
Yes.
Country.
He went to Hajj, my lord.
Compliance report is in fact filed along with the counter, my lord. If the other side wants to verify, let them.
All senior advocates are extended vacation. Vacation
2 weeks.
extended for senior advocates.
Sorry.
Vacation is extended for senior advocates or not? Not
Proxy.
yet. Then how can he be out of country?
He went to Hajj, my lord.
You are there, you are taking the instructions.
Proxy counsel, my lord. Proxy counsel. Proxy counsel, my lord.
Proxy? The proxies are as good as main person. They project themselves like that we are the main person. So you do that and take instructions. He is not, counsel is not.
Please, I leave it.
When the vacation is getting over?
After 24th. my lord.
After 24th. So we'll say that learned advocate, Mr.
Akshay Patil. my lord.
You are Mr.
My name is Akshay Patil for Mohammed Mujassem.
Tripathi, appearing for learned senior counsel, Mr.
Mohammed Mujassem.
So and so stated that vacation for learned senior counsel is likely to get over on
Now the date until
24th. my lord.
simply stand over to. After 24th, you want? 27th June.
please.
Then as learned advocate to the petitioner seeks time, whereas learned advocate respondent stated that the order is complied with, to be listed at 2:30 on 27th.
Please.
बोला
15 वर्षाच्या मागे एकदा गेलेलो. त्यानंच सांगितलं खिन्याला जाऊन बघावं म्हणून. तो पण जाणार आहे म्हणे. तरी पाय कात्री वाला तो बी जातो मग. मला म्हटलं रविवारचं त्यांनी नसतात. मग अक्षयला फोन केलो मी शनिवारी. अक्षय म्हटलं काही नाही कुठं जात नाही असतात ते आमचे भाऊ बंधूच त्यांनी ते गावातच राहतात की सगळं दोघं तिघ आहेत ते आमचे भाऊ बंधूच त्यांनी जात नाही ते असतात. जाऊन गेलो 8वा नंबर लागला सकाळी लवकर गेलो 7:30 8ला पोहोचलो तिथे. 8वा नंबर लागला 10 10:30 पर्यंत संपूर्ण तिथे जाऊन अक्षयला फोन करायला फोन उचला ना आज बी करायला आज बी उचले ना. ऍडमिट होता दवाखान्यात. लिंगायत जात चांगलीच किंवा एवढं काय टेन्शन घ्यायचं.
शहाण्णव फुले मराठा
नाही बीसीबी SC ST मध्ये केली असते तर गोष्ट वेगळी. लिंगायत केले म्हटल्यावर काय. आता समजा ह्यांनी म्हणून करून दिले असते त्यांच्या घरातल्यांनी व्यवस्थित आणून घेतले तर बरं. आणि भांडणं चालू झाली तर आणि काय सगळं एकच घ्यायचं.
Mr. Santosh Sungar, can you mute yourself?
तर हायच चालू.
That's I've secured the records. my lord.
That acquisition.
Yes. Proposal has been sent to the Deputy Commissioner, my lords, to initiate the acquisition proceedings to fix the market rate and grant compensation. But once this is approved, my lords, notification, draft notification will be issued. Lords, calling the objections. Lords, that will be for a period of 30 days. Thereafter, my lords, the final notification will be issued.
Lord, they have taken the possession of the land in the year 1995, my lord. On the promise that they will allot the alternative site, my lord, and also employment for the son of the original petitioner, my lord. Even the writ petition is disposed on 18/4/2023, my lord, and time limit was fixed to compliance of the order, my lord, for 3 months, my lord. Now, after 1 year also, they have not come. Now, even today, they have not issued the notification. That kindly see para number 13 of the order.
So it is initiated. Proposal is forward. No willful contempt.
The time limit may be fixed, my lord, within 1 month or
Lords, it would take
95, they have taken the possession of the line, my lord, 1995.
That's for the procedural compliance, my lords, at least two months is required because we have to issue the draft notification calling for objections.
The page number 37 may kindly be seen from the main operative portion of the order.
The following directions, which came to be issued by a single judge, is ordered dated 18th April 2023. While disposing of the writ petition, are brought under the contempt jurisdiction, claiming of their non-compliance. And this page 37, number 1 and 2. Full stop. And the proceedings come up for consideration today. Learned additional law on Ms.
Pramodini Kishan.
Pramodini Krishna stated that as per the directions issued by learned single judge, the acquisition proceeding has already been mooted, has already been initiated, and the proposal has been made. So in this regard, she produced what we called copy of proposal communication dated 22/5/24 from the office of city municipality, Magadi, addressed to land acquisition office concern. Full stop. Copy of the said proposal was due copy made available to learned advocate Mr. So for the contempt petition. Full stop. Any of the above development of making a proposal for acquisition. Some of the directions could be said to be complied with. Full stop. The proposal shall be carried to its logical end. Full stop. In view of the above development, it could not be said that any willful contempt is committed by any of the respondents. If present contempt proceedings, they are not liable to be continued any further. Full stop. They are closed and disposed of.
The time limit may be fixed, my lord. My lord, 1 year has lapsed, my lord. Till today they have.
You have said that it will take to logical.
That, in that case, my lord, again they will.
In contempt jurisdiction, we are not supposed to pass any direction.
My lord, within the time they have not complied, my lord. Now they have
If
sent
there
the
is
proposal to
unreasonable
the.
delay, you come again by way of.
My lord, I may be given liberty to reopen the contempt proceeding.
We have said that we expect.
Liberty may be given.
Logic, we will expected that the said the proceedings shall be taken to logical end. Expectedly, expeditiously.
Lord, liberty may be given, my lord. Otherwise,
all liberties are there.
Lord, to reopen this contempt petition. My lord.
In view of this contempt liberty. Otherwise not.
Lord, again they will drag the proceeding. Again they will drag, my lord.
No, they will not. They have forwarded the proposal. What
This
more
time limit may be fixed, my lord.
in contempt jurisdiction will not pass this.
So hearing on applications, so number 28. Manisha Kambuvi.
Petitioners in this matter, my lords. Matter, my lords, pertains to jungle safaris, my lords, in the Nagarhole National Park as well as the Bandipur National Park.
So this safari is allotted, safari is by way of some vehicle.
My lords, under a wilderness tourism policy, there were only few categories of people who could operate these jungle safaris. One of them is respondent number 4, is the jungle lodges. They, of course, my lords, operate separate resorts, but they're also given the obligation to monitor and they have, my lords, absolute control over allotment of these seats. Now, as per certain minutes of meetings, my lords, where the principal secretary of the forest was also a part, the understanding was that the petitioner resorts would be allocated 50% of the seats. The total number of seats, my lords, is fixed as per the Supreme Court rulings, my lords. What is the carrying capacity of that area? What is the area in which the vehicles can enter is all already predetermined. That, my lords, neither of us have control over changing. But within the number, the carrying capacity, the understanding was that the remaining resorts would get 50% of the allocation of seats that would enter, and 50% would go to respondent number 4's guests, which is the jungle lodge.
My agreement is entered.
There is some of them agreement, my lords, but this is under minutes of meetings, my lords, because
Minutes
we
of-
were,
minutes of-
please, if I may take my lords to the minutes of meeting, which is at, there were 3, my lords. I'll take my lords to the very first one, annexure R, at page 153. My lords, these resorts, my lords, were pre-licensed in the sense, even before the tourism policy was implemented, these resorts were licensed as ecotourism resorts, who were shown their responsibility. My lords, comes to the next page, 154, that 1, 2, 3, 4 is all I'm seeking protection for, my lords. Within the carrying capacity of a particular tourism zone, jungle lodges and resorts would deploy 50% of vehicles, boats for their guests, and the remaining 50% for the guests of the other private resorts. My lords have that, page 154, my lords. The carrying capacity of sanctuaries, national parks will be fixed by the principal chief conservator of forests from time to time. The government vehicles carrying tourists will be part of the carrying capacity and on count with the quota of jungle lodges and resorts. There shall be no further expansion of existing facilities to accommodate additional number of tourists in any of the existing resorts, which means, my lords, even I was not permitted to really increase my facilities, nor were new entrants permitted, and it was agreed. Principal Chief Conservator of Forests will issue adequate notices and hear the parties concerned before passing final orders regarding the entry fee payable, etc., my lords. My difficulty, my lords, and the reason I'm before my lords is that although 50% of the allocation was happening in favor of the resorts, it was done in a discriminatory manner. There are 2 kinds of vehicles that enter, my lords. One is a canter, and the other is a jeep. The canters, my lords, offer a far substandard experience for any guest compared to a jeep. The visibility is lower. They are
So
not
you are also a
maintained as well.
private company.
where all resorts, my lords, and the.
Number 4 is also a private.
No, number 4 is the
Fully all.
subsidiary of
It's a
statement.
State
Statement.
undertaking, man.
It's under
French
state.
county is state.
No, no,
No,
no.
my lord, petitioner
Respond
number
number
4 is a
4.
private resort. Respondent number 4 is a state government undertaking.
4 is Orange County. Orange.
No, my lords, respondent number.
Respondent
four.
number 4. my lord.
Respond number.
Respondent, my lords.
The grievance is against respondent number 4, my lord.
So respondent 4 is given 50%.
50%, and they are in control of the operation, my lords. Now, in their objections, my IAs arise out of the objections, which is why I'll take a minute, my lords. In their objections, they have said that there is a website on which all of you can book your seats, which is offered, of course, hosted by the Jungle Lodges Resorts. That is respondent number 4. Now, while that is true, my lords, I can only click and book the number of seats. However, whether that seat is given on a canter or on a jeep is not within my control. That is entirely within the respondent number 4's domain. If my lords kindly takes respondent number 4's objections, they have produced certain data. I'm before my lords to point out that that data is incomplete, since there is no dispute that 50% in their objections, my lords, no dispute as to the minutes of
So you are
meetings.
agreed by 50% allocation.
50% is theirs, 50% is the remaining resorts. The difficulty, my lords, is that I am being given only canter seats. So the guests today, it is now known to all the guests that if you want a good seat, if you want to get a good visibility of jungle safari, if you want a good experience, then become a guest of Jungle Lodges. So as a state entity, my lords, we would have expected them to behave in an unbiased manner. Now, the data they've produced before my lords, if I may kindly take my lords to their objections. Annexure R7.
Notice is issued.
Notice is issued, my lords. It's
Statements
We
are,
have
pleadings
we
are
have filed our
complete, my
statement of
lord.
objection also.
Objections.
Yes, my lord. In fact, my lord, that contention of my learned friend is completely contrary. In fact,
Let us see.
yes, my lord. Yes.
May I only point out one thing in their objections, my lords, which is based on which my IA is filed today before my lords. Annexure R7, if my lords takes off the objections of respondent number 4.
IA2.
No, respondent number 4's objections, my lords.
Statement of objection of R4, my lord, at page
To the main
53.
petition. Annexure R7 at page 5353, my lords.
Page
53
53.
of the objections. Data, my lord, sees they've given a daily as well as a monthly allocation to show, my lords. And this, my lords, this website, I have no access to. This data is solely within the control and the access of respondent number 4. They seem to suggest that adequate number of seats have been given to the private resorts in jeeps as well as vans. The data that is missing from before this honorable court, my lords, is what is the total number of seats that went for this morning session on these dates. If that is placed before this honorable court, my lords.
You are not figuring this.
My lords, I am the first petitioner, my lords, is an association of several of these private resorts.
You are the associate.
Please.
In fact, 1, 2,
The
and 4,
remaining
my lord. 1,
resorts,
2,
my
and
lord.
4 are the 1, 2, and 5, my lord.
But my lords are right, all of them are not here. But even if we take, my lords, these numbers, my prayer in the application today before my lords is, please let them place, since they are saying that there is no dispute that yes, 50% allocation should be given to both parties. There is no dispute on the minutes of the meetings. They're only saying that there is no discrimination by them because it's a transparent system of booking that they're following. If that is so, my lords, let them place the complete data before this honorable court, so that today my lords have the benefit of what are the total number of seats or canters and vehicles and jeeps and vans that went in for each of these dates. So that then, my lords, if I have been given 50%, then my lords, no dispute there at all.
In fact, the data, my lord, has all the information that my learned friend is seeking. That annexure R7, my lord, page 53.
Page 53.
53, my lord, in my statement of objection.
Lordship may see the daily allocation and monthly allocation, morning session, evening session. That is how the allocation has been done. Your Lordship may come to page 54, my lord. There we mentioned boat, jeep, van, all three modes. Your Lordship may come to page 54.
Is there any policy in black and white for allocation? Allocation of vehicles, kind of different categories of vehicles to
No,
different
the
stakeholders.
only
Is there any guideline?
Yes,
or
madam.
where is that?
Wild wilderness tourism policy, my lord, it's a national policy which prohibits the carrying capacity. Carrying capacity.
Capacity. Allotment of different categories of vehicles.
Yes.
To the stakeholders who are to be awarded safari.
None to my knowledge, my lords. The minutes of the meetings is what is governing it, which says fair allocation of 50%. Within that 50%, we
say
would
which
have
vehicle.
expected 50% of jeep and van and 50% of jeep and van to them.
Now you are saying that seats are not.
I am getting only van.
Your Lordship may see
I'm
page
hardly
54, my
getting
lord,
any
page
jeeps.
54. Your Lordship may see the data produced in page 54.
We want policy, not data.
The policy, my lord, doesn't say that it has to be given van or jeep. It only says 50%.
So you must be maintaining the jeeps are provided by them or van are provided by them.
No, it's all ours.
Are provided by them, and even the allocation, my lords. I can book 4 seats and I can pay for it, but whether my 4 guests will go in a jeep or a canter is not within my control.
That is the grievance. That he
No, your Lordship.
always gets a van, not jeep.
My lord, second grievance.
Exactly,
of
madam.
course-
My lord, page 54 of my data, my lord, which discloses how many seats in jeep and how many seats in the canters have been allocated. 54, my lord.
54 years.
Yes, my lord. Your Lordship, see in the morning session, boat, jeep, van. The jeep, my lord, is 73. This is monthly this is what, my lord, it's occupied in the April 2022. Your Lordship may see in the previous page 53, the daily allocation and monthly allocations.
All are your members.
Yes.
My lords,
All are your members.
data what I'm asking for, my lords, is that if my lord sees at page 54, the total number of jeep may be 510. But that is only 510 given to me is the contention of the respondent number 4. But the total number of people entered, was that actually double of 510? Did I get the 50%? Or was it 2000 and I got only less? That is the data we're requesting, which should not be difficult, my lords, for respondent number 4 to provide.
All I'm saying, my lord, is that Annexure R7 has the data. If my learner friends want further data, we have no problem. We'll place all those data. It is not that we are not hiding from anything.
Now see, amongst these 5%, there is serious discrepancy. Number 1, Messrs. Water, Wood, Lodges.
Yes, ma'am.
Keep Morning 73. And the second, Orange County, 245 jeeps are provided.
My lord,
That has been
amongst
utilized, my lord.
ourselves, my
That
lord, the
utilized, my lord.
allocation happens because of the size of the rooms, the number of the rooms. If we have more number of rooms, the idea was that we will get
Your
more
Lordship,
number of
see
seats.
allocation, my lord,
Of
is
course,
page
my lords,
53.
Jungle
Page 53, my
Lodges
lord.
But
has
then
fewer.
she said that is 510. Where is the comparative figure?
Your Lordship may come to page 53, my lord, for a minute. Page 53, my lord. Your Lordship may see monthly allocation, my lord, for the water woods. Page 53, my lord. In that same table, which. Your Lordship got 53, my lord.
So you pay to them.
Please, my lord.
You pay to them.
Certainly, my lords. For every seat we pay, the rates are fixed, my lords, again, by the minutes of meetings. So on that, my lords, no objection. In fact, my lords, I may point out that this is not the first time this grievance has come up. In fact, there's an order of the court earlier as well, saying, please do not continue in this discriminatory manner. And that they say they've complied with. Like I said, my lords, the question today is there is no dispute on the minutes of the meeting or the allocation. It is only that are they discriminating or are they not? In which case the fact should speak for themselves. if the total number is given, my lords, not just of these 5 resorts, because our grievance also is that although the minutes of meeting says that there are only no more resorts to come in, there are new entrants to whom seats are being allocated and given and diluting my share. So if the entire data is placed before this honorable court as to the total number of vehicles that went in, total number of seats, total number of Jeep seats that entered, because sometimes, my lords, in lean seasons, lean holiday seasons, that many number of vehicles may not go. The carrying capacity, as I understand now, is around 28, 29 per day of vehicles. That's around 300 odd seats. It may not be utilized entirely on some days. So if that data is placed before this honorable court, my lords, it will benefit. In fact, the petitioners are working with the government to protect these eco resources and natural resources. We're all on the same side when it comes to the forest, my lords. My application is limited only to that extent, my lords.
This is Bandipur.
Bandipur.
See, there are
Both,
3
my lords,
for 3
Nagarhole.
resorts.
Nagarhole and
only.
Bandipur.
Nagarwell.
Nagarhole,
Nagarhole,
that is-
Bandipur and one more there.
Where you stated?
Kabini and Bandipur. The petition, my lords.
Three sanctuaries, my lords, Bandipur,
Page
Nagarhole.
16, para 4, my lord.
Considered the controversy for some time with the help of learned advocates for the respective parties. The petitioner is Karnataka Ecotourism Resorts Association. The members of the petitioner association operate for providing safari services.
Resorts as well. We cannot provide safaris. We offer the safari services. that are
Offer the
also-
safari services.
We are resorts.
The Nagarhole National Park and Tiger Reserve, also known as the Rajiv Gandhi National Park. The grievance raised paragraph and elaborated in the petition is about discriminatory treatment allegedly meted out by respondent 1 Karnataka Ecotourism. Respond number
4, my lords.
4 men.
4, not 4 respondents in making available the vehicles to the members of the petitioner association. What is content full stop? What is contended is that respondent number 4, who is also one of the operators, is favored by allocating a particular category of vehicle always preferred by the tourist to the disadvantage of the other members of the petitioner association. The respondents have produced the figurative chart along with statement of reply of public objection to indicate the number of vehicles allocated to the different safari operators, that's the members of the association. Full stop. The grievance of the petitioner is however that the comparative figure is not made available to the court, which could only throw light on the allegation of discrimination in allotting the kind of vehicles. Full stop. Further affidavit in reply shall be filed detailing giving the aforesaid details, placing on record the aforesaid details. Full stop. The respondent shall also produce the policy or guidelines, if any, with regard to the allocation of vehicles and safaris in the national park. Such affidavit may be filed before the next date, put up on 25th, 27th of June.
Lords, may I kindly direct respondent number 4, my lords, they are conducting, so.
Respondent number 4.
Great.
Number 4 is directed to file.
Great.
Request a few days earlier if that's convenient. for you. If another government advocate doesn't mind filing a slightly earlier.
1st July. Abhi though, there is, in rain, there is no safaris.
Like, in fact, my lord, that what I must say, my lord, that number of seats which we allocated to them, even in jeeps, are going vacant. We are suffering loss. I can place all those material.
So give those figures also.
I'll place all those material, my lord, because unfortunately, my lord, because
You are for number 4.
yes, my lord. We have given them the booking IDs for them to book. If they can book up to 11 PM for 6 AM safari. If they don't book it, then the seats go vacant. So therefore, my lord, the number of
They
seats.
are on the allocation of the category of vehicles.
No, even that. I'll demonstrate, my lord, that even the jeeps I'm talking about, not talking about the canters, I can understand canters, even the jeep seats which were allocated to them, I can place days, every day data for these people to show that even the jeeps which were allocated to them, they have not taken. Went vacant.
You are a semi-government body?
Yes, 99%
Because
of the
it's a
government.
reserved forest, my lords, this jungle lodges, they take care of the safari, my lords. And the private resorts send their guests in our.
Initially, my lord, there
vehicles.
was an issue with respect to allocation of seats. By
We are not
private,
concluding anything, but
Yes,
since
ma'am.
there is some element.
Yes, yes, ma'am.
Discrimination is argued, we are.
yes, I can understand, my lord, I'm only trying to.
There is
place-
some element of discrimination, it appears from their text.
We can place all those material. Your lordship can take a call. It's not that we have any grievances against them, my lord.
25th, if I may.
1st July.
The week earlier, my lords, I'll be obliged. Last week. of June.
We'll have to collect, my lord. In fact, I will place everyday material.
25th will do.
1st July will, 1st July, my lord.
1st.
29 agenda.
Grateful, ma'am.
December 30, regarding non-filing in contempt matters.
Complaint, not complaint.
That's
This is not
state,
complaint.
Not complained.
state is preferring an appeal. A GO has been issued, my lords, to prefer the appeal. So,
Order is of September 23.
Yes, ma'am. Directed to regularize and all consequential benefits has been granted, madam, in a single judge. This is for round of litigation, madam.
You are in service?
I am retired, madam. No, I am retired from service.
Then anytime you can be regularized. No worry.
No, I am aged person, madam. Aged person, senior citizen. Yes,
So only question of monetary benefit, now, even if you regularize.
yes, monetary benefits have to get.
We'll dispose it of
No, my lord.
by requiring them to file the appeal and seek some orders from the court within particular time.
Please,
If you are not able to do, you will comply with the order.
I have the orders here, my lords, to prefer an appeal.
That we believe, we don't dispute it.
Time may be fixed. Time limit may be fixed.
That will do what we are suggesting. Or should
Taking
we,
log,
or
taking,
should we simply adjourn the matter? Court?
yes, ma'am.
Simply
Simply adjourn.
Simply adjourn.
Simply adjourn.
4 weeks.
Yes, ma'am.
Pledge.
When the
6
present
weeks.
contempt proceedings come up for consideration, learned additional government advocate is
6 weeks.
also stated that the decision is taken to prefer appeal against the order brought under the contempt jurisdiction. Full stop. He submitted that the appeal shall be moved before the competent court, before the court, as expeditiously as possible. Full stop. The court grants 6 weeks time within which the respondent may prefer appeal and seek appropriate orders before the competent. So put up on 15th July.
Much of.
For 15th July.
This 31. Sudhindra SCI.
The complainant. But the complainant is a teacher. She was working in a grant in aid institution. She came on deputation to Bangalore BBMP school. She was relieved from there. So no position was given. So no work. And in spite of several representations, she was not given the job. Thereafter, she applied for voluntary retirement. That was also not considered. Again, one more request was made. At least you consider my case for pension benefits, because the complainant is going to attain superannuation by the end of this month on 31st. In spite of innumerable number of requests and requisitions, despite the direction given by the Honorable Court, they have not considered.
That's, the representation has been considered, the endorsement has been issued.
No, we have not yet been served with any order.
He is holding the decision.
Until we come before this Honorable Court in the contempt side, they have.
Now see the, go and collect.
Lord, we will make this matter may be taken up next week. I will go through his.
No, we'll go through.
It is only consideration of representation, that is the order passed by this honorable court.
Whatever you
Without expressing.
consider representation dated 9th March. I need 1 week time. I need 1 year time too. Even then, nothing is sure. So we don't complain when you say that I need 1 week time.
So they have directed the administrative.
You're not comfortable with this?
Yes, well.
We will file the affidavit, my lords, along with the translation.
Rejected. It is rejected.
Let me go through and make submission, Lord. This matter may be taken up.
That's
any
all
other
that
day.
is said in the order, my lords.
This month they are going to.
What kind of decision you are taking? Shunting him from here to there.
Let's, I'll read the order portion of the, let's, paragraph 3. Having heard the learned counsel appearing for the parties and taking into consideration the averments made in the writ petition without expressing any opinion on merits of the case, respondent number 6 is directed to consider the representation of the petitioner dated so-and-so in accordance with law within an outer limit of 8 weeks from the date of receipt of copy of this order.
When you file a petition before this bench for some direction, do we say that this petition to go before another bench? This is what we have done. Instead of deciding, you have said that they let it go to some other authority. That is no consideration.
That's
Why
all.
do you say so?
That's all that we have said, my lords, in the consideration, that is the endorsement issued.
So we lay down the law, what means consideration. You give the translated copy.
Please.
In the meantime, you
Please. At least let them say directly, no, we are not going to consider your case.
You are not in love with Kannada?
Yes, undoubtedly, my lord, I love Kannada.
Everybody is in love with Kannada, but you are seeking 1 week time to read.
No, not that. See, what they have stated is, we have to approach the Adaltam only, the administrative forum.
You find
That
out
is
what
not
is it.
correct.
Appointing authority is the management of the institution, my lords. Therefore, the proposal has to come from there, which is not come here in
In
this
fact,
case.
my instruction says that the grant in aid committee has given no objection.
So you find out.
Lord, 31st, she is going to retire this month.
You are seeking time to understand.
No, it may be considered
Can
because
you give the
with a suitable direction.
Before 31st week.
Lords, the translated copy along with the affidavit will be filed in 1 week's time. my lord.
Next Monday.
Please.
Next.
By that time, she will attend superannuation.
Your senior advocate.
Yeah, please.
Then you are entitled.
Yes.
Let us see what they have decided. If they have decided something, then we can
Let them decide.
Then you have your own remedy.
Please.
Very good.
Much obliged.
Yes.
32 urgent, number 33. Shankar.
My lords, I seek your lordship's permission to appear for the petitioner. This is the public interest litigation, my lords. And this petition is concerning to a class of farmers whose lands are notified as irrigated under Malaprabha project, my lords. Lords, there is a dam constructed across the Malaprabha river, which is usually called as Renuka Sagar.
Notice,
We have
replies.
to, yes, ma'am.
My lords, the notice is accepted.
The file.
Where is it? Where is
Time,
it?
madam.
May I please take your lordship to few of the orders that are being passed by the state authorities, my lord. Sometimes it is regional commissioner, sometimes it is district in charge minister. My lord, all the orders lack any authority of law, my lord.
There is no statement of reply.
But, we'll file objections. ma'am. I will file.
Oh, you filed them.
Please. ma'am. Pray for some time.
Learned additional government advocate wants time to file. What do you call? Statement of objection?
Please statement.
Statement of objection. Spend over to 26th June.
Obliged.
I'm grateful.
Number 34. Madhukar and Deshmukh.
Lord, for the appellant. Lord, the issue is about application of a scheme, Lord, which was introduced in 1993 by the central government for grant of temporary status and for regularization of certain casual workers. Lord, that scheme, your lordship will find at page number 244.
No, but this arose out of CAT.
No, no, no. But, originally, there was an order passed by the Central Government Industrial Tribunal that was challenged. There was a reference made under section 10 of
Not
the.
from the central administrative.
I'm sorry. Lord.
Not from the central administrative.
No, 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 not from central. This is the appellant is a board, Central Silk Board.
Not central government.
Lord, the scheme itself is found at page 244.
Government industrial.
Yes,
Yes.
Lord, the scheme can be found at page 244 in volume 1. Lord, the scheme which was introduced on 10/9/1993 was meant for the employees of the government. Lord, para 1 at page 244. 244, Lord, annexure A, which is the typed copy. It says scheme for grant of temporary status and regularization of casual workers. The guidelines in the matter of recruitment of persons on daily wages basis in the central government offices were issued with a department OMN so and so. Policy has further been reviewed in the light of judgment in CAT Principal Bench New Delhi delivered on so and so. And it has been decided while existing guidelines contained in OM dated 7/6/1988 may continue to be followed. Grant of temporary status to the casual employees who are presently employed and have rendered 1 year of continuous service in central government and other department of telecom, posts and railways may be regulated by the scheme as appended. Now, on the next page, the third item 3 under appendix would be relevant, which says that this scheme is applicable to casual laborers in the employment of the ministries, Department of Government of India, and their attached and subordinate officers on the date of issue of these orders. But it shall not be applicable to casual workers in railway, Department of Telecommunication, Department of Post who are already have their own scheme. Lord, in 1997, some of the employees of the board filed a petition before the Honorable Madras High Court seeking a mandamus for conferment of the temporary status in terms of this order. Lord, the Honorable Madras High Court disposed it off by an order dated 8/1/1998, which will be relevant for my Lord's consideration. But my Lord, that can be found in volume number 4. Volume 4, page 798. 794, my Lord, is the relevant page number. 7. Okay. Yes, the typed copy is at 798. Very short order, my Lord. Now, what I would like to read is at page 799, where, my Lord, their lordships have held. Lord, WP 17969 of 97, page 799. Petition under Article 226, Lord, page 799. Some of the casual laborers, my Lord, who claimed that they are eligible for implementation of this particular scheme had filed the writ petition. Lord, the order is petition under 226 of the Constitution, praying that in the circumstances stated therein.
So you are a board and running various centers.
Yes, I have a few centers. I have a few centers.
All
I'm a board. I'm headquartered in Bengaluru.
All the petitioners are your centers? No.
They belong to the board. They belong to the board, but the people who approached the Honorable Madras High Court were who are working in.
No. Here you are a board.
Yes.
And all petitioners are the production center or selling center.
In the before this Honorable High Court. Yes, my Lord. There are some casual and.
So the employees are of the respective centers or your employees?
Board employees. There is no dispute that they are board employees.
No dispute. Okay. Then let us.
Lord, page 799, Lord. Page 799, my Lord, WP 17969, petition under Article 226 of the Constitution, praying that in the circumstances stated therein and in the affidavit filed therewith, High Court will be pleased to issue a writ of mandamus directing respondent to confer temporary status on the petitioner in accordance with the casual laborers grant of temporary status and regularization scheme, not the very scheme that I just read out to my Lord. Lord, and then petitioner praying, then order. These petitions coming on for so and so. Petitioner, my Lord, the last para. Petitioners are employees of the Central Silk Board, which is constituted act of the Parliament. Silk Board is obviously a statutory body. It is a juristic entity with power to employ people, enter into contracts and perform various functions enumerated under Section 8 of the Act. By Section 11, the Central Silk Board Act, the central government is given power to cancel, suspend, or modified action taken or orders passed by the board. Council contends that on the strength of Section 11 of the Act, that the board is bound by a scheme framed by the central government with regard to casual laborers. That scheme was not framed by the Silk Board, or is there anything to show that the Silk Board has adopted the scheme in respect of its employees? The scheme as set out in para 3 is applicable to casual laborers in the employment of ministries, Department of Government of India, and their attached subordinate office. A statutory body constituted in terms of the special statute passed by the Parliament cannot be treated as a body subordinate to a ministry, and all circulars issued by the officers at various levels in the ministry made applicable to such statutory bodies. That would be negating the autonomy which they enjoy under the statute. The petitioner's contentions are therefore misconceived. Writ petition is dismissed. So therefore, the Honorable Madras High Court dismissed the petition. Thereafter, my lord, there is no further challenge to it, so that became final. In the meantime, my lord, in about 98-99, the union of the Central Silk Board employees sought for implementation of the scheme. And my lord, the management disagreed, and therefore a reference came to be made under Section 10 of the Industrial Disputes Act. My lord, for that, my lord, would your lordship switch back to the volume 1? Volume 1, page number 251. Lord, page number 252 is the reference in volume 1. Page number 251, my lord, is the claim statement made by the workers' union. Page number 251. Please have a look at the prayer, my lord, at page 256. Wherefore, the first party union above named respectfully prays that this honorable court be pleased to hold that the first party union is justified in demanding adoption of the casual laborers temporary status and regularization scheme and the pay scales of the Fifth Pay Commission in respect of the casual and time scale workers by the management of the Central Silk Board. So this petition was filed before the Central Government Industrial Tribunal. And then, my lord, during the pendency of this particular petition, my lord, the Ministry of Textiles voluntarily took steps to consider their regularization. My lord, that correspondence would be very relevant for my lord's consideration. My lord, second volume. My lord, that would be in volume 2. Volume 2, 3. Page number 339 in volume 2. Lord, the Ministry of Textiles directed us, that is the board, to take steps for consideration of a grant of temporary status. (339) Annexure H. Lord, this is a letter issued by the Ministry of Textiles on 25 November 2005. Lord, they write to us, that is the member secretary of the Central Silk Board. And the subject is revision of wages of farm workers of Central Silk Board, suggestion received from Parliamentary Standing Committee. I am directed to refer to Silk Board letter dated so and so on the above subject, and to say that the matter has been examined in consultation with the Department of Personnel and Training and Ministry of Labor. Accordingly, the following observation made. The scheme for grant of temporary status is a one-time affair and is available to only those casual laborers who were in service on the date of notification of the scheme and had rendered at least 1 year of continuous service with 206 days as on that date. This ministry has no objection on various benefit already extended to the casual farm workers, employees of the Central Silk Board based on various statutory provisions as conveyed by so-and-so. Central Silk Board may now proceed further to implement the grant of temporary status to casual farm workers who had 1 year of continuous service with 206 days as on 1/9/1993. It is the date of notification. My lord, once this was received, we proceeded to issue a circular. That, my lord, your lordship will find at page 325. Page number 325. In the very same volume, not Annexure F. Lord, we issued this circular on 15th of December 2005, about a couple of weeks after we received the letter from the Ministry of Textiles. My lord, in this we say, pursuant to the orders of the Administrative Ministry, approval is hereby conveyed for the extension of benefit under the temporary status scheme with effect from 1/12/2005 to the time scale farm workers working in different units, so and so, so and so. And then, my lord, we stipulate all the applicable rules. Then, my lord, what happened was, now kindly turn to page number 470. That would be in same volume. In the very same volume, page 470. Not page 470. This is a letter, my lord, which the Ministry of Textiles issued to us yet again. That is on 29th of December 2005. Now they say, I am directed to refer to this ministry's letter of even number dated so and so on the subject mentioned above, and to say that the tentative expenditure involved in the implementation of the scheme was indicated to be around 6.28 crore per annum. Central Silk Board is now requested to work out the net additional liability for the current year and subsequent annual recurring liability in view of the above referred letter before implementation of the scheme and communicate to this ministry. Earlier, my lord, they had not worked out what will be the financial impact. Suddenly, the ministry realized that there is a financial impact, and therefore they said, we had anticipated that it would be so and so, but you please work out and let us know. We gave a reply, my lord, which is in the very next page, page 471. On 30th of December 2005. Lord, in para 2.
It was referenced by central government.
Yes, my lord.
Which was rejected.
No, the reference was rejected. Yes.
And learned single judge passes the award?
No, learned single judge goes into this correspondence, which there was no relief sought.
No. The page 170 is the direction of learned single judge in the European.
These two documents would be relevant. Before I go to learned single judge's order.
No, we are on a different point. Not on merits, on the principle. Now the reference was rejected.
Yes, ma'am.
Then you filed a petition, or they filed a petition.
No, they filed a petition.
They filed a petition.
They filed a petition.
Whose reference was rejected? Their reference.
Yes, their
reference.
Yes,
naturally. They filed a petition.
They filed a petition.
Then page 169 is the order of learned single judge.
Yes, ma'am.
How can learned single judge pass award? Assuming the jurisdiction.
Yes, my lord. And my lord, he grants relief which was not even sought before him.
Apart from merits.
And moreover, my lord, during the pendency of this writ petition, my lord, they file undertaking. We have given the extension of the scheme from 2015. They accept it. They file memo of undertaking. Learned single judge ignores that.
At the best, it has to go back.
But in this present case, the learned single judge has referred to two Supreme Court judgments, where the courts have taken the view that what the labor court can do, this high court also can do. Now, in the present case, this conferment, there are about 2,000 farm workers working in this central silk.
What labor court can do can also be done by high court is a very nasty proposition. What kind of proposition? We can always do what labor court do. But it doesn't mean that you reduce us to pass the awards.
No,
the evidence is required.
What he has done is that they have accepted this and they passed an order accepting it from 2005. Our claim was from 1993. But we claimed from 1993. The Central Silk Board accepted it from 2005, and they also intimated enhanced the wages. Thereafter, my lord, all of a sudden, without giving any reason, they withdrew this letter. What the learned single judge has done is, what you have accepted from 2005, though our claim is from 1993, the learned single judge has given effect to it only from 1993.
My lord, there is no challenge to the withdrawal. There is no challenge before the learned single judge.
They appointed a committee of their own officers. Those officers, after looking into the conditions, there are nearly about 2,000 workers are there throughout India. They are in dire financial situation and they are suffering from medical ailments. And their own officers have given a report that this has to be extended. Merely because they say that I have financial difficulties, they withdrew it from 2005. Our claim is to give from 1993, which they have accepted, and now, my lord, admittedly, it is given from 2015.
And they have accepted it. Now, what I gave in 2015 has been accepted by filing memo of undertaking before this honorable court.
No, from 2005, my lord, they passed an order. They appointed a committee to go into the conditions of these unskilled farm workers. They work in very difficult conditions. The committee found that they are suffering from various medical ailments, and they said that we will give them the minimum pay scale, even on the basis of equal pay for equal wages. minimum pay of a Group D employee is to be given is the recommendation made by them, accepted by them. Then Government of India writes a letter, on that basis they withdrew it. Now this Central Silk Board is an independent authority. Now the withdrawal is only because of the letter by the Government of India. Then they once again implemented 2015. What was below 2,500 employees were working as on that date. All of them have retired. And they have worked for nearly 30 years, 25 to 30 years. Now below only 1,000 persons are.
You are in service.
What?
You are in service.
No, my lord, about 1,000 persons are in service. 2,300 persons were there throughout India. Out of them, because they did not give, my lord, now about 1,000, it is reduced to 1,000 persons who are still in service. About 1,300 persons, my lord, have continued their service for nearly 30 years. They have superannuated. And their own, my lord, your lordship may just have a look at this human condition, my lord. Kindly see their own report. At volume 3, my lord, only one report I would like to show your lordship. Kindly see their report, my lord, at page 692 in volume 3. They appointed a committee. They accepted it. Our reference was to give us from 1993. But we are willing, my lord, even from 2005 we are given, it is enough for us. But we are in, their report says that all these unskilled workers, farm workers, they have to work in very unfavorable conditions. There is absolutely no protection. They are suffering from medical ailments. And after accepting it and passing an order, giving the salary, they withdrew it, my lord, immediately without there being any reason at all. Kindly see, my lord, their own report, what the recommendations of their own officers. That volume 3, my lord, kindly see page 701 in volume 3.
Lord, may I complete my submission, my lord? My learned friend does the entire field thereafter, my lord.
Because the court asked, I thought.
Lord, the learned single judge has directed that the scheme be implemented in favor of the writ petitioners with effect from 2005.
So are you willing to give some benefit from some subsequent date or?
2015 onwards, we have given, they have accepted it.
15 or?
Yes, they have accepted it. my lord. They have
Five,
filed memo of undertaking. Learned single judge ignores those memo of undertaking.
Scheme is from 19.
They say we will withdraw the writ petition. We say we are happy to accept the scheme from 2015.
Where is that?
Would your lordship
That's
kindly
there in our case.
turn to page number 533. Yeah, volume.
530.
Page 533, volume 2.
Some individual workmen, my lord, they have taken.
No, there are several hundreds of them.
Not by the union.
And those individuals are part of the writ petition. The very same people who filed the memo.
No,
Lord,
whoever has
please,
accepted.
please have a look
can
at
say
page number 525. Page number 525.
There are about 5 persons out of 1,000.
No, there are several of them. There are several memos that I have filed, not just 5.
Out of this is one more.
No, this reason, my lord, for them, my lord, it need not be made applicable. About 2,300 persons are there. Union did not accept. Union has not given made any statement that they will withdraw. We have argued the matter, and thereafter, my lord, the learned single judge has given a finding. We have also given a citation, my lord, that there is no need to remand. Otherwise, my lord, if matter was to
No, Lord,
go to remand, many of them will
Lord,
die.
the substantial
They
question,
have
my lord,
attained superannuation.
which your
They
lordship
are
will
all
also
now
consider is,
60 to 70
Lord,
years
can the
old.
learned single judge grant a relief which was not sought before him? Lord, there was no challenge to the withdrawal of the scheme by. Lord, initially the Ministry of Textile said,
So
okay,
it's
you
not a
consider.
writ
Then it said, please find out what will be the financial impact. When we brought to the notice of the Ministry of Textiles the financial impact, it said, now don't implement. Now that, my lord, that decision which was made in 2006 has not been challenged in any writ petition.
How is Government of India will come in the
No,
picture?
my lord, it is well
Madras High
settled, my
Court
lord. I have
says
got
it is
various propositions to show that the
independent
single
body.
judge, my lord, cannot dole away a relief which was not even sought before him. Lord, of course, Article 226, my lord, is wide enough, but that does not mean that the learned single judge can grant a relief which was not even pleaded.
What
If
is
it was
being
pleaded,
paid
my lord,
is-
I would have contested it.
What is being paid is the minimum pay scale which is being given to a Group D employee. It is not, they are not doing any favor to us, my lord. In fact, Supreme Court has given in AR 2016 that even on the concept of equal pay for equal wages, we are expected to do the work of a Group D employee, and they do not pay us any amount at all. They pay us by pittance of minimum wages. Let we are. No,
It
my
is-
lord, no, we have filed a petition from 1993 onwards.
It is the judgment and order dated 19th October 22, passed by learned single judge in writ petition number, in the writ petition, allowing the writ petition, which is brought under challenge by the appellant Central Silk Board, Bengaluru, in this writ appeal. The respondents herein were the original petitioners. Yes, all were the employees of the appellant Silk Board, who approached the Central
country.
Industrial Tribunal cum Labor Court seeking a reference. Full stop. The competent authority made a reference with regard to the claim of the employees union to apply to their members the scheme for regularization, specifically called the casual laborers into bracket grant of temporary status and regularization, bracket or scheme of government of India, 1993. Full stop. The term of reference was thus, the term of reference before the labor court was thus, quote from page 113. Full stop. The reference raised days above came to be dismissed by the Central Government Industrial Tribunal cum Labor Court, which found that the relief was not liable to be granted to the workmen. Full stop. When the rejection of the reference was challenged before learned single judge, from a learned single judge allowed the petitions. Paragraph. Assailing the order passed by the learned single judge.
Partly allowed. Partly allowed. Our claim is from 93.
Partly learned additional Solicitor General, Mr. Arvind Kamath, firstly submitted that in allowing the petition from a learned single judge took upon himself the function of deciding the reference and passing the award. Full stop. He submitted that the learned single judge virtually assumed the role of Central Government Industrial Tribunal cum Labor Court and issued the following directions. And quote from page 169, one order portion without mentioning order, 1, 2, 3, 4. Paragraph. In addition to the above aspect, on merits, it was sought to be submitted that the similar issue had arisen before the Madras High Court, where the laborers sought the benefit of the very scheme from the Central Silk Board, where against the Central Silk Board itself. Full stop. The writ petition filed by the workmen employees were dismissed by the Madras High Court, observing inter alia that a statutory body constituted in terms of the special statute when special statute passed by an act of parliament, could not be treated at par with a body subordinate to the ministry, and all circulars issued by the officers of various levels at the ministry cannot be made applicable to such statutory body, 4, it would amount to negating the autonomy. Full stop. The claim of the workers were not treated acceptable in law, and the benefit of the casual laborers into the grant of temporary statutes and regulation bracket or scheme of Government of India 1993 was denied. It was next submitted that even if such benefit is to be conferred on the employees, it has to be by positive direction and in a special case. What was the third? Thirdly, it was submitted that the benefits have already been granted to the employees.
Effect from
With effect from 1/7/2015. And from the said date, the scheme is made applicable. Yes. Full stop. It was highlighted in this regard that at the time of availing benefit of the scheme with effect from 1/7/2015, each of the employee gave undertaking, accepting the benefit.
Some of the employees, only some of the employees.
Some of the employees gave undertaking.
127.
Union has not.
127 employees
Union
gave
total
undertaking.
number of employees is 2,300.
Total petitioners.
Some of the employees.
Not 172 petitioners. Out of that, 127 gave undertaking.
Some of the employees.
That is not there in the paper.
Gave undertaking. To accept the benefits. Full stop. On the other hand, learned senior advocate Mr. So-and-so, assisted by learned advocate so-and-so, supported the judgment and order of learned single judge by submitting that in the facts of the case, it is justified. The directions issued are justified. Paragraph. A prima facie case is made out. The appeal is admitted. It shall, full stop. There shall be stay of impugned judgment and order of law in a single judge during the pendency of the appeal. The appeal shall be listed for final hearing after 3 months.
I'm grateful.
About 1,300 employees are throughout the country.
You are getting benefit.
Some early hearing.
Early hearing.
Early
After
hearing.
4 months.
4 months. Maybe after 1 or 2 months, Lord. It's only they are in very difficult situation. Otherwise, I would not have made that submission. They are in very difficult. Either one way or the other, you will not.
Correct. After 4 months.
3 months, you will not.
3 months, 3.
2 months. If I make a request, it should not go further.
3 months is also very near.
Correct.
Two appeals. Both appeals are admitted. Delay will come.
And we have filed an appeal, my lord, claiming it from 93 also.
I heard learned
Both are clubbed.
respective advocates. This is an application for condoning delay of 153 days from the governments made in the supporting affidavit. From a sufficient cause is made out to condone the delay of 153 days, delay is condoned. An application is allowed.
There is a connected appeal also. We have also filed appeal.
Both. Other appeal will
Also
be simply
posted along
admitted.
with this.
In the appeal of Mr. Kamath, there will be stay. The other appeal,
In our
cross
case,
appeal
there
will
is
be
no,
admitted to be heard with the other.
to be heard along with that.
If you don't want admission, to why do you want it?
No, we would satisfied, if this writ petition were to be dismissed, we would never be satisfied with 2005. If the matter has to be argued, we can as well claim from 93 date of scheme itself.
Will do.
Number 35.
For the appellant's counsel in this. Appeal filed by the corporation BBMP against the order of the learned single judge was dated 2nd of March 23. The issue, my lords, in short pertains to what the corporation believes to be an illegal construction of about a short delay. I'm sorry, my lords, I should have mentioned that about 6 days. The issue pertains to, my lords, the what the corporation believes to be an illegal construction.
Yes.
Yes, well, it's back in the year 2021, Manoj. This is when the genesis of this case begins. A notice was issued, Manoj, under the BBMP Act for alleged violation of the, for construction of a building, Manoj, ground and first floor with about 30 commercial shops without plan sanction. This falls within the jurisdiction of the Kodigalli Gram Panchayat erstwhile, Manoj, which later on, of course, got merged into the larger BBMP area. But after a notice was issued on 14th September 21, their replies were filed, replies were considered, and an order came to be passed on 20th of December 2012-21. I won't trouble my lords reading those orders because that order subsequently came to be set aside by the Chief Commissioner. If my lords were to see that order, which is at page 127, the order starts at page 125. So the first order of 20th December came to be challenged in an appeal before the Chief Commissioner. That order was set aside. Could I trouble my lords to take page 126?
One
126 at 127 words. What I would like to highlight was just a couple of paragraphs. I won't read the entirety of the order. Paragraph 6, if my lords has, at the bottom of page 126. So when after notices were issued, my lords, they filed their replies. The respondent's contention is this. It is argued that after purchasing the land bearing 37 guntas in survey number so-and-so of Tindlu village, falls within the limits of ward number so-and-so, on 22/1993, and after obtaining sanction plan for construction of the building from the Kodigalli Group Panchayat, dated 18th of August 1993, and produced Xerox copies of the sanction plan in annexure C and C1. Pausing here for a moment, my lords. When the respondents were called upon to show the plan sanction upon which they constructed the building, they relied upon a so-called plan sanction dated 18th of August 1993 and produced Xerox copies. Now, kindly see, my lords, what the Chief Commissioner says at paragraphs 8 onwards. If I may read once, paragraph 8 on the same page, the appellant has not produced the originals of the aforesaid annexures or certified copies of the same. Moreover, as per the argument of the appellant, approval for the building was obtained on 18th August 1993, and it has been opined that there is a necessity for verifying whether the building has been considered as per the referred plan or violated. On the basis of the above facts, after perusing the documents produced by the appellant as annexures, and if it is noticed that violation of plan sanction, action has to be initiated. In view of the same, it is just a necessary to verify the actual facts and verification of documents, and then it is fit to set aside the order in question, and by issuing notice to the appellant and deviation of the building, if any found in her presence, and to initiate action. So therefore, let's pausing here for a moment, the Chief Commissioner set aside the original order of confirmation for demolition on the ground that
Let us say the order of.
Initially, Manoj, there was an order of confirmation to demolish the illegal construction. That order, Manoj, was dated 20th of December 21, which was challenged before the Chief Commissioner by way of a statutory appeal.
By them.
Yes, my lords. That appeal was allowed on the ground that they are relying upon a plan sanction. However, they seem to have produced only Xerox copies. There is no original. Therefore, we will set aside the order and give another opportunity to the respondent to produce the plan sanction. Therefore, my lords, I read paragraph 9, where an opportunity was given to the respondent to produce the plan sanction. Thereafter, my lords, upon remand, after again issuance of notice, an order came to be passed on 7th of November 22, which my lords will find at page 54. Again, my lords, I'll read only the operative portion at page 55. After referring to the Chief Commissioner's order remanding the matter, after issuance of notice, this is what the respondent number 4 holds. In response to the said notice, my lords has page 55. In response to the said notice, you have submitted your written statement on 11/7/22, and you have submitted the copies of the sanction plan obtained from the Kodigalli Gram Panchayat. As per the measurements of the building have been erased in the said sanction plan. Hence, the said plans were submitted to the Assistant Director, Yelahanka Range BBMP, to attest the same. He informed us that no sanction plan files have been transferred to us from the Kodigalli Gram Panchayat. Accordingly, it has been directed by letter dated at reference to furnish the original sanction plan in connection with your building for verification. Accordingly, you have resubmitted the copies of the sanction plans, which were submitted earlier by you, along with the written statement on 5/11/22. Therefore, by considering that the said building is unauthorized, it has been confirmed that you have violated the building bylaws of BBMP 2020 and also the zonal regulation, so and so. Therefore, the issue was this, that the matter was remanded for them to produce the original copies. Once again, they produced Xerox copies.
Thereafter, what happened?
Thereafter, once again, they filed an appeal. And that appeal came to be dismissed, my lords, by the order dated 4/2/2023.
That is the
at
impugned. that
Page
is the-
49, Chief Commissioner once again.
That is the impugned order. before
That's the
learned.
impugned order before the learned single judge. The learned single judge, my lords, is a very short order. I'll just read that portion, my lords, page 10, if my lords.
What kind of construction? Residential house?
No, my lords, it's 30 commercial offices, shops are there in those two buildings. Now, my short submission is this. The learned single judge, my lords, has seen the impugned orders and has presupposed that it is a valid sanction plan. When all along, my lords, the BBMP has said that on our files, there is no such plan sanction because this was supposedly, allegedly issued by the erstwhile Gram Panchayat, Kodigali Gram Panchayat. BBMP says we have no such file, please produce the original. Till date, no original is filed. The learned single judge presupposes that it is a valid sanction plan and says once there is plan sanction, valid plan sanction, there's no question of demolishing it. It's a short order, my lords, kindly see page 10.
Have you seen? So learned single judge of the view that no approval is necessary.
Yes, my lords. Rather, my lords, he goes into the authenticity of the plan sanction, which is, as a fact-finding authority, my lords, we have found that the documents produced by them are not authentic. In fact, my lords, they have produced it at page 108. If my lords were to see, this is the plan sanction according to them, Annexure M, page 108, which we do not find on our records. We have repeatedly asked them to produce the original, which they are not able to produce. So therefore, my limited submission is this: the learned single judge, with great respect, ought not to have gone into the authenticity of this plan sanction. If there is an authentic plan sanction, a valid plan sanction, then there's no question of any section 248 orders being passed. But when the very authenticity is questioned by not one, but two fact-finding authorities, the learned single judge, with great respect, has erred in presupposing that it's an authentic plan sanction. That's my limited submission. That's all. Of course, in the interregnum, they had filed a suit, they withdrew it. Of course, that.
Your limited submission covers everything. So there is no way out. The building has to be demolished according to.
Well, according to the order, yes, well, that's the.
Yes. My lord, in the year 1993, I put up construction of this building, my lord. In the year 1993, I produced my plan also. My lord, after about 20 years, my lord, after this village panchayat, my lord, the CMC takes over. They assess my property to taxes. I have also produced tax receipts, which clearly shows that it's a constructed building as on that day. And my lord, my property is assessed to taxes, which photographs are also produced. Then, my lord, after 20 years, the BBMP issues this notice, my lord. As on the date when the sanction plan was given, they had no jurisdiction at all. It's only after 20 years, my lord, in 2011, they take over this administrative jurisdiction. They presuppose that there is no sanction plan. They presuppose that it is as per violation of the sanction plan allegedly issued by some authority. My lord, in fact, my lord, their own officer would say the files have not been transferred.
They were entitled to doubt your plan or not? Or
my lord, they are entitled to doubt my plan. Yes, my lord. Yes.
Doubt. They're entitled to doubt.
That is exactly what the learned single judge said, my lord. Can I just take, my lord?
They were entitled at any point of time after vested with power.
No, what they can say
to doubt the authenticity of.
No, my lord, the provision of the law, my lord. Can I make a submission?
No, you yourself are saying that.
No, I'm sorry, my lord, if that was what I intended. That's not what I intended. My lord, what the act would say, the provision would say is that if I am constructing in violation of a plan, or if I have not got any sanction plan, then, my lord, this provision would come into play. Section 248. But that is not so. They said that you already put up construction 20 years ago. Now show me your sanction plan. Now what you have produced is Xerox copy. Since you have not produced original, I presume that it is illegal. That is exactly what the commissioner would say. But had it been a finding that my plan was illegal.
So which kind of originals they did not produce according to?
The original plan sanction itself. At page 108, which they produced a Xerox copy of.
Well, the authorities would have had one set of it.
Those files have not even been transferred, they say. So merely because their own authority, my lord, which from whom they have supposed to take the plans did not transfer, they now say that, yes, I believe that there is no plan or whatever it is, it's illegal construction. 1993, I have produced a plan. Prima facie, my lord, I produced a plan, which is also there, my lord. Now, my lord, it cannot be doubted. Or they'll have to come to a finding that it's a fake plan, or there is no plan, or it is a created, whatever it is. That is not said. They say that since you have not produced the original plan, I now presume that there is no plan at all. So your building has to go. And this authority takes over jurisdiction only in 2011. Before that, my lord, so many things are done and dusted with. Well, merely because, my lord, I do not have a plan doesn't presuppose, my lord, that I don't have a sanctioned plan at all. It is also not their case that there is no sanctioned plan at all. The authority, the village panchayat says, I'm sorry, we have not transferred those files to you. So they say, yes, those files have not been transferred. No, you have not produced originals. So they have their own yardstick and say, yes, it is illegal. In fact, section 248 says, my lord, reasons to believe that there is a violation of the plan or reasons to believe that construction is being done without a sanctioned plan. These two are not there. It's conspicuously absent. And even otherwise, my lord, single judge would say, if they were to find, my lord, I would just take, my lord, the last page, my lord, page 11 of the order. Liberty is, however, reserved to the respondents to initiate action against petitioner if there is any deviation found as regards the plan sanctioned by the Batranpura Gram Panchayat. So, my lord, if they find that their plan itself is illegal or there's a violation, my construction is so and so, my lord, then probably yes, my lord. Not that I concede, but probably yes. Here, my lord, single judge has not gone to presume that my plan is legal. It was my case before the learned single judge. My lord, this authority took over jurisdiction only in 2011, by which time my entire property had been assessed by 2 municipal authorities. And I had produced a plan merely because it was a Xerox copy doesn't say that it's illegal, my lord. And moreover, that was not at all the grounds of defense before the learned single judge. For the first time in appeal, it has been stated. It is 248.
248 is the
Empowers you to
power
take-
of the BBMP to demolish in case there is violation of a plan sanction or there is no plan sanction.
Yes.
So first a provisional order is
I
passed.
produced the plan. Now it is for them to, my lord, say that there is a violation of that plan or that I am putting up construction without a plan. That is not stated. You don't produce original, so it is illegal.
So this section was brought in the statute back in which year?
2020, my lord, the act itself came in 2021 January. At that time, my lords, the erstwhile Karnataka Municipal Corporation Act was in place. For the area of BBMP, my lords, the BBMP Act was enacted in 2020, enforced in 2021. There's one more aspect also, my lords, I'm told, of course, these are all factual aspects which I won't trouble my lords with, but I'm told that they applied for electricity connection only in 2006. That begs the question as to what they were doing for 13 years if they had obtained a plan sanction and constructed in 93.
Have you got the copy of the plan?
I produced it, my lord. All that, my lord, I had, my lord, this was in 2000 after 20 odd years.
Page
I only had a
108.
copy. So which I produced and it is produced by,
Page
108.
108.
my photographs is 116 and 108 is the copy of my plan, my lord. Which was produced annexure M.
Next to them.
There, my lord, the seal of the authority is there, which says 18/8/90, 18/3/90.
Let us see the. Shop.
In fact, if my lord were to kindly see page 54, my lord, that is done by another assessing authority, which 54, it's in Kannada, my lord, but a typed copy, my lord, is in page 94. 94. By another authority called the City Municipal Council of Betranpura, which clearly shows use of building, residential, land and original value of building, etc. my lord, page 25. Item 25. Serial number 25. So throughout, my lord, there was a building and my lord, it is in pursuance to this plan only. Now, all of a sudden, my lord, after 20 years, they asking me to produce, my lord, that is not what is been mandated in section 248. 248 says that if there's a building being constructed without a plan or in violation of a plan, not if somebody doesn't produce the original plan. You know, this is said provisions, my lord, mandates that the reasons for passing such impugned order, which has grave repercussion, my lord, has to be seriously and unscrupulously done, my lord.
Is only a commercial.
Yes, that's commercial.
Or Lord, you are Mr. Vikram?
Yes.
What is the full name?
Vikram, who will go?
Or learned senior advocate Mr. Vikram, full name, assisted by learned advocate Mr. So and so for the appellant, and learned advocate Mr. Senior advocate Mr. Unauthorized. Good name.
Not senior advocate, Unnikrishnan.
Unnikrishnan? No. Punit.
Unnikrishnan, advocate.
Advocate. For the respondent or respondent? Full stop. The Chief Commissioner, Brihad Bangalore Mahanagarpalika. Yes, the original respondent. By filing this writ appeal under section 4 of the Karnataka High Court Act 1961, 61, 64, whatever.
So a delay of what, 6 days, my lord, special. 6 days delay is there in preferring this writ appeal.
6 days delay is gone now. Whom has addressed challenge to judge to order. dated 2nd March 23, passed by learned single judge. Full stop. Thereby, learned single judge allowed the writ petition of the respondent herein original petitioner. Full stop. Order dated 4/2/23, passed by respondent number 1. Thus, the appellant herein came to be set aside. Also was set aside the order dated 7/11/22, passed by respondent 3 authority. The dispute and the controversy in the writ petition surrounded the construction put up by the petitioner on survey number 43/6, Indilu village, Vidya Pranayapura ward, from ward number 9, Yelahanka range, Purhat Bengaluru Mahanagar Palike. It was allegedly an unauthorized construction of a commercial shopping center comprising of different shops. What was prayed in the writ petition was to set aside the orders passed by the competent authorities of the Nagar Palike, Bangalore Nagar Palike, ordering the demolition of the building on the ground that the building was put up since SANS authorization and approved plans. Paragraph. It appears that against the order dated 20th/12/21, passed by the assistant executive engineer, of the subdivision concerned, treating the constructed building to be unauthorized and without supportive of approved plans, the petitioner filed appeal number 104/22 before the office of the commissioner. Before the commissioner. The chief commissioner considered the issue between the parties to notice inter alia that the Xerox copy of the plan of the constructed building and other documents were produced. However, the appellant had not produced the originals of the said annexes, nor the certified copies were produced. The case of the petitioner appellant was noted by the chief commissioner in the order disposing the appeal, in the order dated 10/6/22 disposing of the appeal, that the approval for the building was obtained on 18/3/1993. And that it was necessary to verify whether the building was constructed as per the default plan or in violation of the plan. For the purpose of verifying the facts on the site on that score, the appeal was allowed by remanding the case to the assistant executive engineer, Vidya Ranpura. By setting aside the order dated 28/12/21, further directing the assistant executive engineer to consider the file afresh and pass fresh order after examining the merits. Full stop. Assistant executive engineer passed order dated 7/11/22 after undertaking exercise of press examination of the dispute of the controversy. And after affording opportunity of hearing to both the sides. The assistant executive engineer, BBMP, ultimately ordered in exercise of powers under section 248 into 3 of the Barahat Bengaluru Mahanagara Palika Act 2020 to demolish the building, recording a finding that it was constructed by the petitioner unauthorizedly. Full stop. The petitioner was further directed to stop the construction. The said order was carried in appeal before the appellate authority. And the same was confirmed on 2/24, was confirmed by the appellate order dated 4/2/23. It was the said appellate order dated 4/2/23 which was brought under challenge before on a single judge and came to be set aside by allowing the petition. Having gone through the relevant orders, having gone through the orders passed by the Mahanagara Palika authorities, standing in the background, some of the facts emerging and the documents available from record, and upon considering the rival submissions, the court notices inter alia that in the earlier process of consideration of the question whether the construction was supported by the plan, public approved plan or not, the authorities held against the petitioner. It was also sought to be pointed out that the approved plan was never forthcame, and what was produced was only Xerox copy. It was further highlighted on behalf of the appellant that under section 248 of the 2020 Act, the commissioner concerned has powers to demolish or alter the building, the work of which was commenced, carried on or completed unauthorizedly. paragraph. Before not before, while setting aside the impugned order dated, while setting aside the order dated 4/2/23 and allowing the petition from a single judge recorded thus, which is the only part of the reasoning supplied by a single judge, which is the only part of the reasoning supplied, full stop. And quote paragraph 2 on page 10 and 11. Case could be gathered from the compass of the controversy. It has several aspects and dimensions about the authenticity of the plan, whether the plan was approved or not, whether the Nagarpalika could exercise the powers under section 248 of the Act, and whether in the case of the original petitioner could be accepted that since the construction was put up only in the year 1993, any approval was not as such necessary, full stop. In light of the compass of the issues arising as above, the court finds that the order of learn a single judge is cryptic and non-speaking. Full stop. Learn a single judge was expected to examine in its length and breadth all the issues arising as above and those others which may be argued by both the sides. Full stop. While this court does not dwell into the merits of the case of the either side, since the order is found to be non-speaking and non-compliant of the addressing of the issues involved, non-compliant of the fully addressing the issues involved, the same is set aside only on the said ground. Full stop. The proceedings of the writ petition are remanded to learn a single judge for deciding the controversy afresh between the parties. Also, the parties will be at liberty to file the additional pleadings if they so want. Paragraph. It is provided that it is expected that the learn a single judge will decide the writ petition expeditiously. Having regard to his own calendar. Full stop. It is further provided that till the writ petition is decided, the parties shall maintain status quo with regard to the subject matter. Full stop. The petitioner is not permitted to transfer, alienate, or deal with in any manner the entire property constructed or its segments in the nature of shops or any other kind of construction, nor shall be permitted to alter the status of the property.
Permit me to lease, my lord, because there are many tenants from 20 years. I can, if they vacate, I can, at least that can be permitted.
It is clarified further that the passing of the above restrained direction does not reflect on the merits of the case. Therefore, the appeal is accordingly allowed in part.
Number 36. Ravi Shankar.
Petitioner's appeal
Hearing for the statement.
agreed by the notification of the government, taking away the granted land of the petitioners to an extent of about 6 acres, 30 guntas to form.
Granted in what manner?
Granted to me, granted to me because I belong to a depressed class many years ago, which is admitted by the state. Minority, belong to SC/ST communities. So a large tracts of land were available for the government. They dispersed it many years ago, but an extent of 6 acres, 30 guntas was carved out of this land for formation of a scheme called Ashraya scheme. So I noticed, the petitioners noticed that the government was trampling on the lands of the petitioners, so they came before the learned single
Are you
judge.
utilizing the petitioner's land?
My lord, if the learned order is looked into at page 23, para 4.
My grievance is,
That is why the question.
So the learned single judge states that not to look into or take the lands of the petitioner, no portion of the property belonging to the petitioners will be
the
utilized.
learned government advocate
So-
makes that submission before the learned single judge. That is recorded in page 22, para 3, to the extent that the lands of the petitioners will not be trampled upon or touched upon. Dehorse this particular statement made by the government advocate. Still the lands were taken. Therefore, I came up before this court passed a considered order on 21/7/23.
21/7/23.
Yes, ma'am.
Where is that order?
Order sheet.
Same order, impugned order? No.
No, ma'am. 21/7/23.
Where is it? Page?
It's in the order sheet.
Daily
Order
orders.
sheet.
my
Daily
lord.
order.
Daily order.
This
in
court
this
noticed that I had produced about 3 survey sketches that is produced by the revenue department themselves.
21/7/23.
Yes, I may be permitted to read that. Para 2, my lord. On perusal of the material placed on record, it reveals that there are 3 sketches. First sketch is at page number 235. Document placed at page 234 is a covering letter dated 23/2/23. And contents of this document indicate that this particular sketch appears to have been drawn on 23/2/23. However, there is no reference of date in the said sketch. Then there is another sketch placed on record by the appellants by way of an application IA 223 filed by this court on 27/6/23, which is at annexure in at page 258. Perusal of the said sketch show that there is markable difference in the first sketch and the second sketch. There is no reference to the date in the sketch at page 258. Then the appellant has placed on record third sketch at page 261 at annexure N1.
Yes, sketches are produced by you.
But produced by me, prepared by the revenue department. So
You
that
say
this,
that the
this
state-
court found, my lord, that these 3 sketches, one do not relate to the other. And it would in fact then directed the Tashildar to come up with an affidavit and to prepare a sketch. The Tashildar prepares a sketch which is identical to the sketch that is already produced by me. And now, despite the fact that there is a status quo order, they are now going on with the construction. That is the factual aspect. And this honorable court on 2 occasions have held this Ashraya scheme itself is void ab initio. That is the ruling of this honorable court.
My lord, with regard to
These are the rulings of this honorable.
Whether you stick to your stand in the paragraph 4 or not.
my lord, I need to get instructions from the Tahsildar because there's a lot that has transpired. Now, essentially what the.
In the order, where is this? In the order impugned in this writ appeal, from a learned single judge has specifically recorded with reference to the sketch that no portion of the land of the petitioner, your school.
No, individuals, 5 individuals.
Petitioner shall be utilized for the purpose of Ashraya scheme. Full stop. However, this court in order dated 21/7/23 highlighted the discrepancies in the different sketches produced to call upon the respondent authorities to make their stand clear as to whether the statement recorded in paragraph 4 of the order would hold good. Full stop. Today, when the case comes up for consideration from a learned additional advocate, Ms. So-and-so was in want of the final instructions. Therefore, she may take final instructions as to whether any portion of the petitioner's land is likely to be utilized for Ashraya scheme or not.
The Ashraya scheme itself is held to be void by this honorable court on 2 occasions, based on the Supreme Court judgment. Therefore, legislature, it's very clear. So
If it is
therefore, the
void,
question
then
of
they
them
will-
implementing.
If it is void, then they will not take, then
They-
you
they
will
have been
dispose of
doing-
the petition.
lord?
You dispose of the petition, recording your statement that Asara scheme is held to be void.
Yes.
Therefore, there is no question of the state government taking away.
And they're still trampling upon my rights. I belong to
Correct.
the weaker
So we
section.
dispose of the
My
appeal.
lord, the question is whether they are.
That he
lands-
is saying that Asara scheme is illegal. So there is no question of, there is no,
Under the Ashraya scheme only,
your statement decides your appeal.
despite the fact that this
Your
honorable.
statement that Asara scheme is illegal decides your appeal.
No, despite the fact they are doing under the banner of Ashraya scheme.
Oh.
Despite the fact that on twice.
So we are asking them to whether
Let
you
them-
are going beyond and beyond. Spreading your wings like anything beyond the controversy. Saying that Asara scheme is illegal and void. We are not concerned with the Asara scheme. We are only concerned with the directions of the single judge under appeal. And the council will clarify on the next occasion, next Thursday.
Please, my lord.
Interim order.
Interim order is there?
Yes.
Interim order granted earlier, so continue to operate till the next. Yes.
This is number 37. Muralidhar
For the
SR.
appellant. I am for the appellant in this case now. This is with regard to the impugned order passed by the DRT. I have come up with this, with the writ petition, and upon the dismissal of the writ petition, I have come up with this writ appeal. Upon the dismissal of the writ petition, I have come up with this writ appeal. And now there are 3 items, my lord, items, properties were mortgaged to the bank. Initially, I had challenged the securitization application order passed by the DRT. And later on, immediately after the disposal of the securitization application, the bank has auctioned the properties. All my 3 properties were auctioned. 2 properties they have sold in auction. My humble submission now is that, my lord,
You are ready to settle.
The
my lord,
properties,
it was for settlement, but by that time, the securitization application was disposed of, granting the liberty to the bank to auction the properties. Now the properties are auctioned. 3 items were auctioned, and the 3 items were mortgaged. Item number 2 and 3 has been auctioned now.
Residential house.
Yes, please, my lord, residential house. And the item number 1 is not yet sold. The total amount realized through the auction is 1,93 lakhs, my lord. The notified loan outstanding amount is 1,23 lakhs. Therefore, I am seeking the bank, I am requesting the bank to transfer the surplus amount whatsoever they have realized. And apart from that, the item number 1 is there that has not been sold in auction. And the notified loan, outstanding loan amount, 1,23 lakhs has been already realized. The item number 1 may kindly be discharged. And the rest of the amount, surplus amount may kindly be returned to me. That is my humble submission.
Item number is a separate property.
Yes, please, my lord. Separate property.
there are 3
Three
properties.
houses,
3 properties.
3 different properties.
3 different. One is
Different
site.
3 different properties, my lord.
And
One is
the
residential
council said
site.
that one is not.
One is not
subjected-
sold, my lord. One is not sold.
2
May I
which are
make a request?
subjected to auction could face the value equivalent to the loan
My
amount.
lords, may I make a request to kindly take page number 4 of my objections, my lords. I have given a tabular column as to how the amount is utilized. May I make a request, my lords, page number 4 of my statement of objections, my lords.
Or of statement.
Para 8. My friend is saying, well, it's outstanding is 1 crore 26 lakhs. On what basis has not been shown? I have also produced annexure R1, the notice. Mills may, para 8, Mills may read page 4 of my objections.
Paragraph 8.
8. As per auction held on 9/2/2023, the following properties were sold for the sum mentioned below. Item number 1 not sold. Item number 2 free sold. The tabular column furnished para number 9. There is still outstanding of 49 lakhs from his side. He is only a guarantor. Plus cash credit which has been adjusted is 1,56,000, 17,000. Outstanding is nil. The second loan, vehicle loan, is there's still outstanding of 30 lakhs, 82,000. Cash credit plus the third loan is also closed. Fourth, the term loan, out of which still 18 lakhs is outstanding. If my lords were to kindly take annexure R1, my lords, the sale notice, which this sale notice was challenged before the DRT. Para line number 4, my lords, 1 crore 23 lakhs outstanding as on 2/6/22 with further interest at the rate of 12.25% from 21/6/21 compounded with monthly rest and all cost charges due to the bank and represented by so and so. He is one of the guarantor, my lords. She is the second wife. There's the first wife who has also filed a essay which is pending consideration before DRT. Plus against an order, DRT, if my lords were to kindly take the orders passed by the DRT, he said that there is no question of arguments after the sale was confirmed, and against which DRT, he ought to have filed an appeal before DRAT. He approaches learned single judge. Learned single judge dismisses his writ petition.
Yes, why you are sitting standing silent?
I have appeared for the DRT.
DRT has been made.
You are for DRT.
DRT.
You want to go for mediation?
Well, there's no question of mediation, Mullets, because all amounts, there are two rival claimants. One is the first wife, the second wife petition is pending.
No, that
The
will be-
property which has not
that-
been mortgaged.
That will be decided by the civil court. The case is already pending before the civil court in that regard. That
There
will be
is-
decided by the civil
There
court.
is still
And so-
outstanding of 49 lakhs, Mullets. If they were to pay that amount, including interest, Mullets, bank has no charge on any of the properties. Bank would release immediately.
My lord, as per.
49, let him pay 49 lakhs.
So 192 is realized.
192 is realized and there is
23.
outstanding of 49.
Is the loan amount.
Loan amount.
And there you can, rest of the 49 lakhs, you can adjust from 190.
That has been adjusted. After adjusting, there's a balance of 49.
My lord,
That adjustment is also been given. There were 4 loans.
my lord, my humble submission is 1 crore 23 lakhs is the notified amount. That has been given in the notification.
The council beyond an extent will not be able to go into the matter because we can
And
try to the extent
his
possible.
his
that
remedy lies before
My lord,
DRAT.
there is-
Against an order of DRT, my lords, his remedy lies before DRAT as per the apex court judgment.
No, my lord.
He comes before this honorable court. May I pass on
My
that,
humble submission,
judgment,
please,
my
my
lords?
lord.
Which is the latest judgment?
My lords, 2023. Pass on the against section 17 order, my lords. The last
The right to property of the appellant.
The last para of the order, my lords. Para 36, last page, my lords. Para 36.
In one judgment, the Supreme Court deprecated the practice of going to the High Court.
In this case only, my lords.
This case on,
In this case only.
this is 23.
Para 16, my lords.
16.
Para 16.
But now learner single has entertained the petition.
Learn single judge is dismissed on a different ground, my lords.
Paragraph 16.
16.
16 तो है नहीं है. It is not
Approaching the High Court for consideration of an offer by a borrower is also frowned upon by this court. and para 55, my lords. Para 55, it is a matter of serious concern despite repeated pronouncement of this court.
Same,
The High
same.
Court
Same
continues,
judge.
para 55, my lords. High courts continue to ignore the availability of statutory remedies under the DRT Act, Surface Act, exercise jurisdiction under Article 226, and for passing the orders which have serious adverse impact on the right of the banks and other financial institutions to recover their debts. We hope and trust that in future, High courts will exercise their discretion in such manner with greater caution, care, and such. And in this case, an order passed under Section 17 by the DRT is appealable under Section 18. Plus, if they have to prefer an appeal, they will have to deposit the amount, she being the guarantor for the loan. To avoid that deposit, my lord, they have preferred a writ petition.
My lord, while in the proceedings of the DRT, the principles of natural justice has been violated. Thereupon, I have come up with the writ petition, my lord, not otherwise.
May I read the orders passed by the DRT, my lords, which is at page number 156. May I read the para 5, my lords, at page number 158 as to why DRT dismissed the orders. Tribunal wide, may I read that para 5, my lords? Tribunal wide proceedings dated 9/2/2023 had given liberty for the bank to proceed with the sale. However, sale confirmation was deferred. The matter stood advanced by the respondent bank as the sale confirmation was deferred. When the matter was taken on board on 8/1/2023, the applicant counsel refused to argue the matter. Hence, interim order of stay was granted and matter stood posted for 10/3. On 10/3/2023, applicant again refused to argue the matter and sought time to file objections to the rejoin. Hence, last opportunity was given to the applicant to file objections to the rejoin. It's seen that respondent bank has already filed objections on 2/3/2023. Today, when the bank matter is taken on board, learned counsel for the applicant submits that he has filed a memo of settlement which is served to the bank counsel. In memo of settlement, it submitted outstanding amount of 123 to be paid in 5 installments as detailed in the memo, specifying the date of payments mentioned in the memo of settlement, which is opposed by the respondent counsel as a property, is already auctioned and sale certificate is deferred. Learned counsel or the applicant submits applicant intent to settle the liability, and there is no question of arguing the matter. Submits essay may be disposed of. The counsel for the applicant along with the party in person, responding counsel along with the bank officer is present. Courts admits, acknowledge that the contents. Applicant who is present also acknowledge essay may be disposed of in memo of settlement endorsed in the proceedings. As the applicant and counsel submit they intend to settle, nothing survives for the consideration. What is not argued before the DRT nor before the learned single judge. For the first time, my friend is bringing up before this honorable court.
I had sought for the settlement, my lord. I have filed the memo. That is on record.
And
the page number 142, my lord. That is the memo of settlement I have filed. I was in the intention of clearing the whole sum by borrowing the money from
after the
some other
property was
sources.
auctioned, everything, he files a
And
memo.
therefore, I refuse to argue the matter because the memo of settlement is there. In terms of memo of settlement, the SCA may kindly be disposed of. That was my humble submission. But that was not considered. And even during the proceedings, my lord,
as on January 2023, the principal was 1 crore 23 lakhs. It is not the outstanding liability.
Not the thing.
As to how my learned friend arrives to that consideration is not forthcoming. The principal itself was 1 crore 23 lakhs. Annexure R1.
I have filed the order sheet, my lord. It is in page number 147, 146 and 147, my lord. On 9/2/2024, my lord.
You go because there is claimants are also more than one rival claim.
They are more than one.
That
There
can
are
be-
two rival
My lord,
claimants.
My lord, that has to
Plus
be decided
annexure-
by the civil court. My humble submission is that while in the proceedings before the DRT, the matter was set down for
If you want to-
objections on 12/4/2024.
Your client wants to go before the bank with some proposal representation, do it. and withdraw the petition, appeal. Otherwise,
No, I will approach, my lord. My humble submission is the amount whatsoever has been auctioned. Let the surplus amount whatsoever is there, that may kindly be returned.
There is no
And
surplus
so far
amount.
as,
Still
so
they
far
are
as
entitled to
the
pay the bank.
item number 1 that is not yet sold, that may kindly be returned back, my lord. Because the lien whatsoever made is only the special liens made by the bank. That cannot attach all the properties whatsoever is there because of the outstanding amount. Because the specific lien is there only with regard to the amount whatsoever borrowed, and the item number 1 to 3 are confined to that contract only. That cannot be attracted to other adjusted to other loan accounts.
that is
The,
all.
ma'am, I have filed few citations, my lord, in that regard. With regard to the contract whatsoever made by the bank, because the equitable mortgages whatsoever I have made, that is the specific lien made by me to the bank. That cannot be adjusted to the other loan accounts. If at all, if it is to be adjusted to the other loan accounts, he has to approach the court and he has to seek the remedy before the civil court. That is the only thing. But he cannot adjust all my properties to the loan accounts. Because the lien amount, the lien is a specific lien, my lord.
Nowhere, no documents are produced that it has not been mortgaged to the bank. The loan, there are 3
No.
loans, there were 4 loans.
The
which were
contract
borrowed.
is as such, it's a specific lien. When there is a specific lien, it has to be confined to that particular loan account only, and that cannot be passed on to the other properties.
Now
That
here
is my
the-
humble submission, my lord.
Here the water has flown much. Auction
Please.
is held, amount is realized. It is still inadequate and
Till
rival
it is
claimants are there.
There's
Civil rights are being agitated.
one more essay been filed by the first wife, which is pending before the DRT.
Dismissed.
Number 38, AMC Basuraj.
It may be kindly taken up next week. It may be taken up next week.
Next week.
Yes.
Here for transport corporation.
I appear for the.
Next.
For order still number 39, Mr. Somsekhar KH.
Order has been complied with.
Complied with.
Please. I'm placing the endorsement on record.
So what was the direction?
Direction was to consider the representation. Considered the representation and passed an order. And issued an endorsement to that effect to the complainant. I'm placing that on record.
But actually, my lord, there is a scheme by the BDA. I am the landowner, my lord. My land 36 guntas has been taken by the BDA for formation of Arkavati land.
Direction in the order of law and a single judge date 13th December 22 was to decide the representation of the petitioner dated 18/8/22. It is this direction which was brought under contempt jurisdiction for its non-compliance by filing the present contempt petition. Paragraph. Today, when the proceedings were taken up, our learned advocate Mr. So and so, for the respondent stated that the direction is complied with and the representation is decided. Full stop. In this regard, he produced copy of the order of the endorsement dated 23/4/23. rejecting the representation. Full stop. Since the order is passed as above, comma, the court finds that there is a due compliance of the direction of learned single judge. Nothing survives in the present contempt proceedings. The contempt proceeding is disposed of as not surviving. If it is observed that if the petitioner is aggrieved by the decision taken by the competent authority, from a recourse in accordance with law and on merits will be permissible for the petitioner.
To challenge the endorsement. To challenge this endorsement, my lord, liberty may be. It's number 40.
Wanted time. Yes, after 4 weeks.
They were supposed to comply the order, my lords, today.
What is that complaint?
The matter was taken before the other court. Being the contempt, my lord, my friend advocate Basaraj appears with a senior counsel. They filed an affidavit. The timelines is prescribed notes to make the payment. They made a payment and 4 crores was supposed to be made by this day. But they required some time, my lords. It could be, senior counsel is also not present today. It could be taken the day after tomorrow or next week.
My lords, they have already violated their own affidavit as well as the court orders that is open now.
But that's the reason I made, my lord. The matter was posted for further orders. The matter was heard. Affidavits were filed.
They were given 1 month time to comply. with
Even
this.
otherwise, there is no time. On next Wednesday.
Please.
Number 41.
Your Lordship, I hear for complaint, Your Lordship. Last date of hearing, Your Lordship, directed with the comment responding to release the balance amount. What had happened, Your Lordship? I am the owner of the trees. They have permitted me to cut the trees, Your Lordship. Thereafter, they auctioned. And I sought for a direction to release the money which is fetched in the.
Only thing left out is the interest part.
Yes, sir.
You are there.
They admits that they made the part payment. In their affidavit, Your Lordship, when they filed the last occasion, they say that they have made the part payment. And therefore, Your Lordship directed them to release the balance amount. And also the Your
So
Lordship
they have
interest
30
also.
30 lakhs is released.
I will have to seek instructions because the balance payment is to be paid. Initial payment was made to them.
That is the only controversy.
That is,
A week's time may be granted. to them.
Next.
please, Your Lordship. Wait.
42 is for withdrawal.
42.
Some withdrawal process, I think. Yeah. Nobody is there. After 2 weeks. After 3 weeks.
Number 43.
Here for the petitioner.
For the respondent, Lord, the filed amended petition I have received. We seek, not 3 weeks time for filing.
My lords, I had filed an application for impleading myself, my lords. I'm the petitioner in the connected matter. At my instance, my lords, the lease that was granted to them was set aside. So I may be permitted to be impleaded in the petition. And I
Lord,
may
I-
also be permitted to file the objections, my lords.
For impleading, I have filed detailed objections, my lord. It can be considered on that day.
On that day.
Yes, please.
3
Yes,
weeks. 3 weeks. At the request of learned advocate, learned government advocate, Mr. Mahindra, stand over to 3 weeks will be 2nd July.
Lord, one submission. Memo for retirement by the earlier council. That's on record. That may be,
Who is earlier?
yes.
K.N. Subba Reddy. He is retired.
Earlier council has retired.
The bar that learned advocate Mr. K.N. Subba Reddy, who earlier appeared for the writ petitioner, has withdrawn his appearance and is retired from the matter. The official take note of this submission and delete the name while notifying the petition on the next day. Full stop. At the
Connected
request of
matter
learned
also.
government advocate, in order to enable him to file the reply.
They're together.
Send over
Connected matter also.
Send over to 2nd July.
3 weeks, huh?
Number 44.
In 44.2, my lords.
Is 44 that bauxite and land?
Yes, my lord.
It
Yes,
will-
my lord.
It is covered or what? It is some judgment of the other high court?
Kerala High Court
Ah.
judgment is land.
Will take up after some time.
But my one submission is that in 44.2, there is one office objection that though they have supplied me a copy of the statement of objections, but that is not reflecting. So that may be taken as complied, so that this matter will come up for preliminary hearing. My
So in all matters, stand over to 3rd July. As paragraph, as per as read petition 4235 of 23, office objection is dispensed with.
yes, ma'am. So a short date may be given. Ma'am.
2nd July.
45 minutes.
No, 45.
Of matter. But I understand this and my only submission is this.
45 is connected.
45 has a lot of connected matters. That matter relates to recruitment of about 10,000 primary school teachers.
But it is a writ petition.
That's right, my lord. There are various petitions which are connected. Writ
It arises
petition.
out of the order of.
My lords, there are orders of the tribunal as well as orders of the learned single judge. Since the issue involved is the same, my lords, they are all connected together.
Cat matter will come here.
Let's SCAT matter.
No, it is not a writ appeal, writ petition.
Writ petitions now.
And is there any order to take both?
Yes, my lord. There's an order tagging both these petitions.
Judicial order.
Writ petition and the writ appeals together. My only submission, there are about 10,000 primary school teachers recruitment which is stalled. There are about a few thousand lecturers recruitment which is stalled. My only submission is, my lord, if your lordships can accommodate it. Since the academic year, my lord, is starting and the students' admissions have taken place.
So how come that learned single judge dealt with the cat subject?
My lords, the tribunal, my lords, relies upon the learned single judge's order to pass the impugned orders. Now, my lords, the order of the learned single judge is challenged in writ appeal. The order of the tribunal is challenged in writ petition.
They are cross as such.
No, my lords. Yeah, they're all, my lords, sailing together.
Cross.
Yes, my lord.
Challenge to learn a single judge
And challenge to the tribunal. Because my lord, a few thousand.
Whenever all of you are ready, we are ready.
Subject to your lordship. That's my only submission.
Well,
Because primary school teachers and government.
Blood writ petition filed by the state 863 of 24 may kindly be tagged along.
You are the teachers.
We are all seeking candidates who are seeking recruit.
In 45.1, my lords, I apply for the caveat.
And what the cat has done, cat has stayed.
No, my lords, CAT has virtually altered our positions.
Namely?
Let's, in the sense, this is pertaining to, my lords, reservation in Article 371, the Hyderabad Karnataka issue. Now, my lords, so virtually, my lords, thousands of recruitments are stayed. My only concern is, of course, not as candidates, but as students, my lords, they should not be put to prejudice
State
because
petition
of
is also there. We have preferred a petition.
All will take them.
Please.
When there's some element of urgency. Because
any convenient.
Several litigants.
Students' interest.
Correct, whatever. July, 2nd week.
Yes.
June last week, if I can.
June last week. June last week, 25th of June.
So great.
We'll try to.
My lords, in 45.1, I apply for the caveat. We have not yet been served.
Any other matters?
Sir, connected matter, connected matter.
Any other matter? Group is fixed. 25th, 25th we'll try.
Very, very grateful.
My lords, in 45.1, I apply for the caveat. We have not yet been served. There's office objections not yet been complied in 45.1. That may kindly be.
I'll request my colleague, my lords, he's online. I'll tell him.
My lords, kindly, my lords, in 45.1, my lords, we've issued no objection, my lords, to engage any other advocate, my lords. The file has been taken up, my lords, from us. So therefore, my lords, I have no instructions in that matter, my lords, in 45.1. I'll be filing a memo for retirement, my lords, in this matter.
Very
My lords, in that case, may I request that maybe de-link, my lords, 45.1, because that pertains to KPTCL and this pertains to state recruitment. That can be de-linked from this batch. That is a separate recruitment process.
The order that is impugned in 45.1, my lords, is what is relied by the KT, my lords. So therefore, it may be all considered together.
Yes.
Grateful to my lords.
All those miscellaneous things we'll do when we hear them.
Grateful. there is some sort of interim order subsisting in these petitions. In whichever it is there, it may be continued. Great.
Interim leave shall continue.
Very
to operate till the next. Shall continue to operate.
Grateful to my lords.
27th till 27th.
Very well. Very well. Grateful.
So to be listed on 25th, interim leave to continue till 27th.
Number 46.
Read petition 863 may kindly be tagged on.
Lords, in serial number 46, my lords, I pay for the state. Lords, say 46, my lords, the first matter, writ appeal 200 of 2024 is a state writ petition, my lords. And my lords, 46.5, my lords, is a state writ petition, writ appeal 212 of 24. Lords, matter is ready to be heard, only one difficulty.
Lord, I'm appearing in the connected matter, my lord. That requires to be heard, my lord, that.
Lords, only one request for the state in 46.5, my lords. Only in that notice is not yet complete because the notice is not issued. 3 of the respondents, my lords, are appellants in 46.4. So we may be permitted to take out notice on them, my lords. For the remaining respondents, my lords, will take out process, my lords. And if
you want notice in 46.5.
Please, my lords, only in that government appeal, my lords.
That is also.
Apparent in 46.4, my lord. I will be undertaking to file wakalat.
46.5 notice returnable on whenever the matters are kept.
Number 46, I pay for the
After 4 weeks.
counsel for the caveator. There's a delay of 139 days on the part of the government. Since the connected appeals are already not, delay may be controlled, so that matter can be heard. The first matter, appeal 200 of. Yes.
So what about the office of the
Lord,
3 weeks?
I think.
Only one is left.
Lord, may I request for, my lord, the fixing of.
For charge. No pleadings are required, my lord, just the arguments and the charges to be framed. So at least, my lord, some priority in the list, cause list is what I'm praying.
My lord, 47.1, interim order needs to be extended. 47.1, so interim order.
This is not solved.
The matter was listed on the top of the list, my lord, because it is hearing before charge. And now it is, my lord, not reaching for several days. I'm praying, my lord, some priority maybe.
Charge for what? Contempt?
Yes, my lord. It was, the contempt was, my lord, prima facie found. It's
Criminal-
only for framing of charges, my lord.
Criminal contempt.
Civil contempt. Disobedience of the order of the division bench.
Yes, madam.
Serial number 53, your lordship.
Serial number?
53. There's an urgency in the matter, your lordship. It was a date given matter today. It may be posted on Friday, your lordship.
What is the urgency?
Urgency is that the government is trying to pull down a forest land, your lordship. It's a public interest litigation. We already notice has been issued in the matter. It had to be heard, and the interim order is what we are praying for, your lordship.
No, there is no urgency, Lord. We have recovered forest land. There is an order. I shall place it on record.
He said the other matters in relief is granted.
No, 53.
Next Tuesday.
Serial
Much
number
obliged.
52, serial number 52. There is a direction from this learned single judge for payment of compensation within 6 months. Even after expiry of that merit, there after 7 months also they have not paid compensation.
Will spread over.
Lord, interim order needs to be extended,
All
Lord,
interim orders
47,
will be extended.
please.